Item number 1. With this, Your Lordship. Lordship, this PIL is regarding the violation of Forest Act, Your Lordship. So basically, NIT.
You are representing whom, Mr. Abab? State. State. Union and the state, PCCF. So can you get your instructions with regard to the grievances raised by?
My lord, that can be done, but my lord, recently we have completed 25 years of my lord, long period. Now I believe, my lord, we are no longer in nation state. Since there is a, my lord, Guwahati High Court Public Interest Litigation rules are there, 2011. My lord, this item should be complied with, my lord.
How do you, is there any violation of the rules?
Yes, my lord, the rule 10, totally, my lord, they have forgot, my lord.
What is that?
My lord, before filing, at least a representation should be given to the completed one. And other than, my lord, for me, my lord. It's an item, my lord.
All right, you bring that on record, whatever objections you have.
And secondly, my lord, we lost my kindly see the status of the petitioner.
He's a member.
He is, my lord, Finance Secretary of Papupare from district. And I believe, my lord, he is a busy body, but
No, your belief by itself doesn't help. You have to bring it on. Throw it, and essentially they are questioning that the forest land without denotification has been sought.
now, my lord, to which forest land? Because we have a, your lordship is knows, my lord, there are, my lord, Durpur region of forest, my lord. Whether there is no any whisper, my lord, that this area falls under which forest it is.
No, see, there are two ways to do it. Either we issue notice
My lord.
or you get your preliminary instructions. Depending then upon that, we will decide whether we should.
Very well. Then your lordship may not issue any notice, my lord. Let me take the instruction, my lord, whether the need comes at any region of forest or not. That can be. Because, on my mobile RTA, your lordship, that reply there, clearly from that NIT goes under the forest name, your lordship.
Page number
84, your lordship.
yes.
And very next page, Your Lordship, in 85, department has also wrote letter, complaint to this one, Director of NIT, Your Lordship, complaining regarding to acquire clearance, Your Lordship.
Yes, but this is let them get the instructions here. What is the status? Yes, Mr. Nawab.
Yes. Spot number 2.
Seeking directions. The respondents. Disclose as to how the campus of the NIT Arunachal Pradesh for the campus of the NIT, how 301 acres of forest land of Papum Reserve Forest has been earmarked without clearance and NOC from the concerned authorities as is required under the Forest Conservation Act 1980 and also as to how such proposed construction such land can be reserved for construction of the NIT or nothing without the safe forest land being denotified. Mr. Nawab, on the other hand, submits that this PIL been filed without compliance with the Guwahati High Court PIL rules as 2011 has no representation had ever been issued. Was submitted before the competent authority. So, be that as it may, we permit the respondents, we permit Mr. Kamu and Mr. Naba complete their instructions as to the status of the progress of the proposal for establishment of NIT or Arunachal Pradesh, whether as alleged by the PIL petitioner, due clearance for construction of the safe project on 301 acres of land stated to be forest land has been obtained from the competent authorities. Depending on the instructions that are placed before the court, next day we consider issuance of further orders if the needs to arise. The petitioner will ensure service of extra copies of the responding counsel. This again after.
Sir, मला 2 weeks मला your lordship has not proposed मला NIT मला is already functioning मला is not
It was functioning.
functioning.
NIT already established.
Yes, ma'am. After oblige.
Item number 2.
One thing, connection arising out of same judgment, another writ appeal is pending, it's not taken. Writ appeal number 03 of 2021. The writ appeal that
You want both these matters to be listed.
yes, because it's arising out of same issue.
When I is there, then let it be listed together.
What I believe, matter can be taken up in day. The consequences will follow. If this appeal is allowed, then that will cover. There's nothing to adjudicate further.
No, if the similar matter is pending, the idea is to, not allow different courts passing different orders in similar matter. That is the problem.
Council representing in that particular case, they have a different proposal of length of argument.
What I thought of, at least my brothers would have informed me yesterday that there is another connecting writ appeal, so that I would not have
They
burnt my
wanted to give
midnight
you a
candle.
pleasant surprise. They wanted to give you a pleasant surprise.
But that surprise, has taken a toll on me. In any case, all right,
This morning I could work out, that's
Very
up
good.
to know that after having talked with the other council.
But I am so glad. Government council should not be a adjournment council. At least my brother has done some exercise. Very good. Good sign. In any case, Milord, when do you want this one?
It is submitted at the bar.
Apang sir is there, representing that particular case.
It is submitted by you are for the education department.
Yes, madam.
You're Mr. Jamo.
Madam T. Tagu, madam.
T. Tau. Mr. T. Tau. Standing counsel for the education fund. Something that data connected with the bill. Also pending, right? That's it. Being read bill number
03 of 2021.
03 of 2020. So submits that for these legal bills be listed together. Mr. Tara, council representative. Phillips. Submits that the matters can be listed together but on an early date. Mr. Tapo, or Mr. Tapo, in case of the private respondent section, respondent 25 and 26. Tell us when you want this again.
5 in this, in respect of 25 and 26, well, we have done a paper publication by means of substituted means of service.
That's okay. They appear in the meantime, they appear.
That's fine.
So we'll keep it on which date?
After 2 weeks, any convenient date.
Listed after 2 weeks.
Public.
Item number 3.
Dear Your Lordship, this matter was taken up on 21 August. Thereafter, notice was issued. However, Your Lordship, in the order, since this is a POCSO matter, arising out of POCSO matter, the victim's notice has to be issued through
Respondent,
police station.
respondent who?
Yes, yes. The said direction has not been given in the order.
Notice has been issued, you have to take steps.
Uh,
Notice was issued on 21/8.
yes, yes, yes. Your Lordship, the victim's notice has to be issued through jurisdiction police station. Police station.
That's right. It is for you to take steps.
I have apprised the registry office. They
Otherwise, you have to take it to the office of the PP.
Actually, in the order, it does not reflected to PP or to the office.
That's in view of the judgment. No?
Because it is only simply by the register post. So he wanted to
All
take
right.
a step to the OC in charge process, person jurisdiction.
By earlier order dated 21/8/2025, notice was issued made making it returnable after 3 weeks. So, however, as per directions of this court, in what is the judgment? So and so. Direction issue takes steps on the respondent number on the respondent number 2 in the office of the PP, and notice be served by the jurisdiction station. The report thereof be served before the office. What's the name of the judgment?
Deepak Nayak closing.
Deepak Nayak. Deepak Nayak reported it to this reported. As well as in the IA. That's in the IA also.
Yes, Lordship.
Same order in the IA.
Item number 4.
Agency for opening the day of 200 days. 230 days. You know, I was just for serving after that delivered in the month of December 2020. This is an IA for condonation of bills.
Pharmacist. Section account applicant. So that was
Yes, for all respondents.
for all the respondents. This is an application filed under section 5 of the and it's paying for consideration of the of 29 days in preparing the connected appeal. So, should not be reasonable by police since Mr. Patel appears and accepted office on behalf of all the respondents. Well, no permanent execution. That you have object.
Take instruction.
Okay. This is matter for.
Item number 5.
My lord, this IA has been filed for non-action of day of 47 days.
We should notice at this stage. That
All right, all right.
So I bring to the permission of 47 days. Degree filing the company. It's a debt in an order to change will pass to the. This. The hearing or response? The rest of it. All there is one. Paper notices the waive the extra copy condition within a period of 1 week. Today, respondents. Party and I their objection within this document.
Oh, that is all right.
Item number 6.
Item number 6. This is a similar nature of case.
How many days?
Almost same, challenging the same judgment.
Same,
There was common judgment.
same order. Here the delay is for 47 days.
48 days, 1 day more.
Let's say. Return and vote.
All right.
Item number 7.
So pending before the principal seat has been transferred. That's how perhaps it has come about. Otherwise, pleadings are complete. Can be fixed for hearing. Tell us which day. After the vacations. Mission. That's Kelly. The amendments made to the recruitment 2009. Promotion, so assistant station superintendent. Which department? Transport. This case was originally filed to the principal seat and pursuant to orders passed. The matter has been transferred. Placed before this court. Submitted by Mr. Moikia appearing for the petitioner, Mr. Chaudhary, and intending for the state of the that the pleadings are complete. That matter be heard. Be listed for hearing on 27th October. 27th October. October. Be listed on 27th October.
Item number 8.
Lordship, I'm seeking for adjournment on behalf of Mr. T. Tofu. Lordship, leading concern out of station for medical ground. So, Lordship, matter may be adjourned for 2 weeks.
The request is made on behalf of Mr.
T. Tofu,
T. Tofu.
Lordship.
Taken to be out of station on medical grounds. The paperwork has been prepared and served on parties. The trial court records are also available. Let the matter be listed for hearing. Immediately after 2 weeks.
Much obliged.
Item number 9 and 10.
Yes.
Lord, item 9 and 10, I'm appearing through VC. I am Naveen Kumar. Lord,
We
in
have heard
item
you.
10,
We are
the pleadings are
hearing
not
you, but we
complete.
can't
In
see you.
item 9, union has filed its counter. I am audible, my lord? Video got freezed.
Yes.
Am I visible now?
Yes, you are visible now.
So
Yes.
this relates to challenge, constitutional challenge to section 10A 2B, the proviso which was added in the amendment of 2021. Lord. The union has filed counter in item number 9, but the pleadings are not complete in item number 10, my lord. So let the pleadings be completed. My lord may hear it because it's after all it's the uh, rules checks are passed by the union, so union view will be very important, my lord. Meanwhile, I will file my rejoinder to the union's counter in item number 9.
Who's required to file? Who's required to file the affidavits?
Actually, item 10 has been.
Lord, in item
I
number
give
10,
my
both state and union.
We will be one further time.
In item 10.
Item 10. 9, it's a old matter.
9 you have filed, but the rejoinder is yet to be filed. You want to file a rejoinder? Counsel for petitioner?
I will file rejoinder, my lord. I'll file my rejoinder, my lord. I'll file within 1 week, my lord.
You are Mr.
Naveen Kumar, Naveen.
Naveen Kumar, counsel. You represent the petitioner in both the matters.
Yes, my lord.
All right, Mr.
I
Naveen
have
Kumar
appeared in
counsel,
earlier dates.
appears in item 9 and 10. In item 9, the state has filed their affidavit and the petitioner would like to file a rejoinder affidavit. In item 10, the respondents pray for further time, file their counter affidavit. Let both these matters be listed. Let the pleadings be completed and the matter be listed after 4 weeks. Let it come after 4 weeks.
Deeply obliged, my lord. Deeply obliged.
Yes.
My lord, I'm aware of the matter pending for the last 2023. It was listed on Portman.
On board.
Board.
What is the matter?
Then company.
Board.
Please, Lord. Lordship, I will mention one unlisted item. Which
Unlisted.
Lordship,
Why?
Lordship, this is the pending matter.
Then why are you making it unlisted?
Lordship,
What
for
is the-
withdrawal, for withdrawal. For withdrawal, Lordship.
For withdrawal.
Lordship.
Again for withdrawal.
No,
What is the argument? Transfer and posting.
Item number 1.
As per order dated 25/8/2025, the respondent authority have issued a notice to inspect the award and collect the document. However, the petitioner went to the office of the respondent number 5 yesterday and to collect and inspect the document. But the respondent, they've informed that the document which is being sought by the petitioner is not available with them. But, to that effect, I have filed an affidavit also this morning.
You filed an affidavit.
Yes.
It's on record.
Yes.
You should notice it. Copy of the affidavit.
This morning only I filed.
Serve in the court.
Yes, but that's what they are showing is only that the approval sanction letter of the award.
Paper. Pursuant to the order. Right. Third five. Respect of that. However, on being, however, papers are not available.
Yes.
And he was not allowed to inspect reports. And what about the award?
Award only lordship. They are not saying that is not available.
Okay, the award is also not. Then take out. Right. Back so. State. Right.
Yes.
Sir.
Wide it up.
Write it up. It is for all the respondents.
State respondent.
State respondents. Respondent 1, 5, 6.
Your Lordship, 2 is not there, Your Lordship. Yeah, it's 1 to 7, Your Lordship.
1 to 7. Step 4. B. Basically, these are the evidence to be right by the petitioner to be and connected to the police report and counted to so state council. State after.
Lordship, I have an interim prayer in terms of section 38(1). Lordship, till the returnable date, the status quo will be maintained on the land of petitioner.
Or land has already been acquired.
Yes, Lordship, but payment is not been done. But section 38 of the Act, Lordship, says
Let us see here. 2013 Act,
Yes, Lordship.
2013 Land Act. Have a right to go and appear before I think the arbitrator. As per the 3G, 5G there. Like.
Unless the petitioner received the award, copy of award.
You are only concerned with the amount of compensation.
Yes, Lordship. Even I don't know how much of amount has been
That is all right.
yes,
but
determined for.
Are you challenging the acquisition itself?
No, Lordship, I am not challenging that.
Then what is the point in asking for status quo?
Lordship, 30th says the deputy collector shall take possession of the land after ensuring that full payment of the compensation loss. Because the requiring body is going to carry out the activities over my land.
That issue notice on the print.
Yes.
What is the status of acquisition? He doesn't have any instructions.
Yes. The rest of the beneficiary landowner, they have received their amount.
Maybe.
And now the acquiring body, the deputy
The next returnable date, the deputy commissioner, collector, deputy commissioner. Which district?
COB.
Huh?
COB.
COB. Will which section you are referring to?
38(1), 38 subclause.
The next returnable date, the collector will ensure compliance of the mandate of section 38 of the so-and-so Act. What status quo? You are not challenging the acquisition?
So once the activities is started, then my land will be.
Your land will go, but you are entitled to compensation. You have a right to question the compensation. One term. Unless you challenge the acquisition itself, that the acquisition is not necessary for public purpose. Where is the question of status quo?
I am challenging for the compensation only because that whether my amount is being determined in accordance with the properties, standing properties of my land or not.
Then
Even
then you have to challenge the acquisition itself. You're agreed by you don't mind your land being taken away.
No, Lordship. But I need to be paid
You
adequate
only want-
compensation, Lordship.
Exactly. So your compensation will be looked into.
Yes, for that only, Lordship, I
But
have to know that
allowing the
whether
land-
my
No, then have you received any compensation?
no, Lordship,
Nothing.
no.
Therefore, the collector is directed to ensure compliance of the direction, compliance of the mandate of section 38 of so-and-so Act.
As per our previous instruction, out of 38%, 31 is already.
He says he has not received yet your instruction.
Yes, sir.
Please take out again. Right. We are issuing notice on your interim prayer. Meanwhile, collector will ensure compliance of 38.
Deeply.
Item number 2.
Please, my lord.
Yes.
Yes, my lord. The petitioner has filed the instant writ petition in the peculiar circumstances that the bank, that is UCO Bank, earlier granted term loan of rupees 1 crore 11 lakhs to the petitioner. Then the petitioner has repaid those loan amount within a period of 3 years. Subsequently,
What are you challenging here? What are you challenging here, Mr. Sinha?
yes, but challenging is that madam, now again first property has already been sold pursuant to judgment of OA, my lord. The second property is also again going to attach and also it will be sold, my lord. So now my prayer is that we are going to file appeal before the appellate tribunal, my lord. The main judgment was not challenged till now. So we are going to.
When was the appeal filed? When was the appeal filed?
My lord, appeal was filed in the year. That is judgment. I have annexed, my lord.
When was the order passed?
Yes, my lord. Order was passed ex parte, my lord, on 25/7/23, my lord.
Then
Ex parte order, my
when
lord.
did you come to know? When did you come to know?
No, but that is the notice they have issued for execution, my lord, by through WhatsApp, my lord. Your lordship will find there is a finding of the honorable tribunal also, my lord. In the notice was not served at page 57.
When did you come to know about the order?
My lord, when the execution notice was issued in the year 2024,
When was it issued?
issued on 19/7, 19/11/24.
So from
19/11/24.
24, what have you been? From
No,
24, why have you not filed an appeal?
So, my lord, because my lord, we have filed SADR for to stay this notice. So, in this way, time rolls up, my lord. So, my lord, therefore, what that just we are taking time to 3 months time.
No.
We'll file an appeal before the tribunal, appellate tribunal, my lord. Till date execution of second scheduled land.
No.
Well, only for that.
Your grounds for interference are not germane. 24, the order was passed. Under Section 18, you have to file an appeal.
Yes, my lord. Yes, my lord.
And from 24, this is more than a year. You are still preparing and taking steps to file an appeal. Now you're coming to the court trying to stay the attachment order.
No, only for 2 months or 3 months, my lord. In the meantime, we'll file an appeal. After that, repetition maybe, my lord, dispose of.
No.
Only for
We are
this period,
dismissing
my lord.
it right away. We
My
are
lord,
dismissing it
just
right
my
away
interest of justice, my
without
lord.
issuing notice. We are dismissing it right away. The question is whether we impose cost or no cost.
My lord, kindly, my lord. Otherwise, that because the loan amount he has already paid during the COVID only.
What is your explanation from not filing an appeal since the year 2024?
Yes,
What is your explanation?
explanation means your lordship will, but because time to time we have filed essay, then miscase. This and also in this way times rolls out, my lord.
You were aware under the provisions of the Act, under Section 17, when an order is passed, your remedy is Section 18 appeal.
My lord, ex parte order was passed, my lord. Someone also not served actually.
Ex parte, but you came to know about it when
24,
the execution
only
was issued in 24.
Yes, only when notice was, my lord, that also, my lord, in the WhatsApp they have sent it. In the WhatsApp 19/11/24, immediately we have filed essay, my lord, before the tribunal so that the scheduled land should not be executed or attached. Well, in this way, time rolls out, my lord. Again now,
Who's the counsel for the bank?
Bank, my
Who's the
lord,
counsel for the bank?
the bank, I think that notice is served, I think to them, or deputy commissioner is notice is served.
Is there any
No
standing counsel?
No standing counsel there, my lord. In Arunachal, there is no standing counsel. And
We
only
are not
2-3
issuing
months.
notice. We are not issuing notice.
Only 2-3 months, man. We are going to file.
No. You make out a case, Mr. Sinha. You are a very astute counsel.
Yes,
you are aware of all the judgments.
I know.
Time and again, the apex court has come heavily
Yes, my
on high courts interfering in surface matters when the statutory remedy is there.
Yes, my lord. Yes, my.
Then what is the ground to make out an exception?
My lord, then notice may be issued, my lord. That in the meantime,
No. We are not issuing notice. We are not issuing notice. If we wanted to issue notice, we would have issued notice on the last date. This matter was adjourned for none had represented the petitioners after filing the writ petition.
My lord, because the second schedule land was because already I have two.
We can only give you one opportunity. If you can serve an advance copy on the UCO bank and make their counsel appear before the us, we are willing to hear you. Otherwise, we are dismissing.
Okay, my lord. Advance notice will give. Okay, that may be allowed, my lord.
No, that we are not allowing it. It is up to you whether you want to serve advance copy on the council or on the bank.
Yes, my lord. That matter will be adjourned for today. We will serve a copy to them, my lord.
All right. On the request made by Mr. BP Sinha, matter stands deferred to be listed again after 1 week.
Yes, my 1 week.
1 week.
Item number 3. Three and 4.
Please, Your Lordship. Lordship, last occasion, state was directed to take instruction. APSSB Standing Council was directed to take instruction.
Who's the standing council?
The Tapin he was represented.
Where's Mr. Tapin? We'll just put it up after a while.
All right.
After one.
Item number 5 and 6.
Yes.
Come up for it, along with item number 2. Notice was already there, item number 6.
Yes. Yes. All right. What is your? This is the. You are agreed by the clubbing of the posts.
Segregation of the qualified candidates, basically.
But that is how the examination was advertised, and these procedures were already advertised.
Not advertised. That is the whole case. Change the rules of the because this is the selection process has not even started. This is a filtration test. So Rosie may kindly have the item number. Compartment. Item number 22 also.
6 or 7.
6.
380. 380 is shown as item 7. Yes.
Kindly have made 35.
Yes.
Now, my lord, the selection process is only a written test and a bio of the case. This preliminary examination only in case there are large number of candidates. In case there are large number of applicants for service mode, the commission review necessary and conduct the recruitment time, hold the written examination directly. Yes, but there are large number of candidates. The selection process starts from the written examination.
Yes.
Then madam will kindly have of the qualified applicant examination. Here time the number of advertised both vacancy or decided by the commission of the applicant to the written exam. Your time. Yes. Then others are matter of the kindly have based practice that the petitioner are matter petitioner with in civil. We are concerned with 7 departments. The total advertised more than 166. We are concerned with 136. Why don't you see the advertised 9th of May 2025? One is public works department, 71 post banner. Who is PHC and water supply, equipment department, water resource department. Likewise, matter urban development, urban local police, hydropower development. There are 7 departments that the civil engineers are qualified. Will explain for example. Serial number 7.
Yes.
Your segment time here, page number 58.
Yes.
Now the civil engineers can participate in all these departments, up to CM number 7. That is up to my water resource department. Now, along with this, the candidates of agriculture engineering degree are taken, they qualify for hydropower development, RWD, and water resource department. Now, this comes to 134 posts, by this 102 for the first 4 posts, that is PWD, PHE, and urban local code. That is 102 posts. And 34 posts for RWD, PHE, and water resource department. Now, civil engineers are qualified to participate in all these 7 posts. Now, your lordship will kindly have page 59. What method of selection? The eligible candidate will have to appear in requirement examination of the following subjects. So this is the selection process. For this, we have to undergo this examination. Now again, in case of number of applicants more than the desired ratio, the commission may conduct a recruitment based on the following scheme and pattern. So just a preliminary examination so that to filter out the candidates. The 134 post ballot 12 times comes to 1632 ballot. Now, since there were more than 5,000 candidate ballot, they went ahead with this ballot preliminary testing. Ballot will all appear. Then, my lord, by page 62, the result of this was declared. At page 62, you also will find the first 4 department ballot, PWD, Public Health, Engineering, Water Supply, Urban Development, and Urban Local Code. For this ballot, they selected ballot 105 candidates. 102 more is near about 12 times. So nothing wrong with it. Then, my lord, at page 66, you also will find there's another list for Department of Hydropower Development, Well Works Department, and Water Resource Department. And there, my lord, they selected 414 candidates. Now, out of this 414 candidates, my lord, 362 are seen here also at page 63. (362) candidates are in the list where for these 4 departments. They have been again put in here. There are 52 agri engineers who have qualified, and that is how the ratio of 12 times have come to minus 1600. But at the preliminary stage, the civil engineer candidates have been barred from participating in these 3 departments. I could have understood it by not having done the written examination. But how can they do it in the preliminary examination?
So how is the ratio worked out? Is it worked out post-wise?
No, my lord. They could not have been. The advertisement does not say anything.
Where is the advertisement?
Civil engineer candidates are qualified for this total 136 posts. Advertisement starts from my lord. Page 55. Yes.
So 1 to 7.
1 to 7. Comes to 136 posts. These last 3 departments, my lord, the candidates who have agriculture engineering also qualified. What, my lord, it appears what they have done in the affidavit for what I have found out.
So 1 to 7, what is the total number of posts?
136.
136, yes.
We are qualified for all the 7 posts civil engineering students. So 136 into 12 times, my lord, come to 163. But, my lord, for these 3 departments where the agricultural engineering candidates are also qualified.
While you fill up the form, is there a preference indicated?
Yes, there is a preference indicated, but it's a preliminary examination. The selection process only starts, my lord, at the level of written examination.
Yes.
That is the whole thing. But at the preliminary stage itself, my lord, more than 800 candidates, my lord, civil engineering candidates have been deprived from even opening their candidature for this, my lord, 34 more. My humble submission, that they could have done only after written examination, not at this stage.
So which 34 posts? 34 more, so Lordship and kindly have page 8. Start from seal number 5. Hydropower Development Department, Rural Work Department, and Water Resource Department. Here, my lord, candidates having agricultural engineering as well as civil engineering are qualified. What they have done is for these 3 posts, my lord, they have put out a separate list. However, my lord, that separate list includes 362 who are in the earlier list also. That is how, my lord, 1600 has come. That is 12 times. This, my lord, in my humble understanding, could not have been done at this stage, my lord. Now, what is the next stage?
6 and 7, my lord. The main examples. My lord, what I'm praying, my lord, if my lord was further determination, my lord, let my lord 362 candidates, my lord, results be declared, and let them have the written examination subject to what the outcome of this honorable court. Since the exam has come after a long time, my lord. 2022 also after the yes, no, my lord, was cancelled. So the same post that was developed at that point of time also.
Yes, Mr. Rama.
That is will not be possible. It can be possible only and when the exam is postponed for another 5 or 6 months. Because there are so many steps to be taken before issuing admit card, arrangement approved. So many things are there.
But one thing, same roll numbers are
Yes,
reflected.
I have explanation for that. Even I did not understand at the very outset. That was my question. Now, if I may permit, then it's like this. It's a combined examination. The common examination. Now, when we say common examination, then it comprises of many departments. And whereas in many departments, the recruitment rules are different. Say, PAC, 3 departments are there. PAC, WRD, and RW. Their required qualifications and subjects are different. Therefore, common selection is done in combined examination. Common qualifying marks are given. Now, say PWD is eligible for these 2 departments in that even in separate tables. PWD candidates, they are qualified for PWD, PAC, RWD, WRD, and urban development, and urban local bodies, and hydropower department.
PWD means civil engineering.
Yes, civil engineer. So they are qualified for this. And the for for agricultural engineering, for hydropower development, RWD, and water resource development department, the required subject is degree is civil engineering and agricultural engineering. In agricultural engineering, agricultural engineering will not be qualified for PWD and PAC and UD and urban local bodies. So there's a difference. So it's first civil engineering. There they are qualified. First batch of selection candidates, selected candidate And second one, they are qualified for 34 posts. Only civil engineering and agricultural engineering degree holders are qualified. Now, if we will have to understand that combined examination, common examination, we'll have to understand that first. In common examination, we have single question paper. Single question paper, but selection will be done for both according to merit. Now, in case of civil engineering, we have 102 posts. Here, for this, who are qualified, those having all the required subjects. Then here, selection will be 1:12. In 1:12 also, it has compartments again for physically handicapped people. That will be kept for
Those reservation apart, to explain to us your mechanics of your process of selection. Then supposing for 102 posts, civil engineers are qualified. Yes. Now, across departments, various departments, yes, you are reflecting the same numbers.
yes,
Which ultimately covers the 102 posts. Then what happens is there are seven departments. There are 7 departments. If you have same roll numbers, assuming that person gets ultimately selected, person will have to be appointed against only 1 post.
yes, yes.
Now for the 6 posts or 5 posts, where the name is reflected, there has to be somebody else who has to come and fill up.
It's not there. Now, first, if in fact this was introduced from this year only. This year only. Otherwise, earlier year, it was all separate exam. Say for power, separate.
We are not questioning your decision to have uniform exam for fighting. Because it is advancing. For one vacancy, you are inviting 12 persons.
Yes,
In the zone of possibility.
yes,
And so, let us say in civil engineering department, there is 1 post. Yes. Say the person whose number appears between 1 to 12 will be considered for the zone of possibility. Then for the post of say hydro power department, again you have 1 to 12. Now it is according to him, who are displaying more or less the same roll number against all these posts. Yes. As a result of which, this cutoff of 12 has not gone down to 12, isn't it? That's so. If for one civil engineering post, if 1 to 12 is there, and we assume that only 1 person will be selected, then for the next zone of consideration, it has to be, let us say, 2 to 14 or something like that. Or 2 to 30. That's it. Unless you have a mechanics that is on the basis of preference, first preference, second preference.
no, it's not prepared. It's not prepared. It's the marks, merit. It's the merits. Now, there are 2 compartments. There are many compartments out here, but in
What is the total number of posts? 107. 130. 7. What is 160? You don't qualify for it. No. How many? What is the vacancy position? 136. 136. That is so 136 into 12 are 4. Then, however, it's here and there. Let you consider about it. This is 62 were not very important. Somebody left up. And here is a case panel. Because of this segregation, more than 800 But now, if 136 posts are available, effectively, only 136 persons can be appointed out of the 1600. So what they are doing is they are holding the examination and selecting 1:12 respect of all the vacancies. So from 1 to 1600 or whatever the cutoff is, roll numbers are there. From there, further selection will be taken for selecting 133 candidates. There is not an issue, madam. What is 34 was what they have done as per the on the basis of merit, they have calculated that differently, 34 into 12. They would not have done it. That is why I have submission. Because we civil engineers, we are can participate for this 4 posts. There is a separate preparation as well as for the 34 posts. How can they have the selected at this statement? Somewhere in the advertisement is provided that will be done in that manner, madam. Then change the rules of the game with you, madam. That is why I have submission. So the advertisement nothing, madam. There is no cheaper. Then 34 posts, more than there will be a different list. Where do you say 12? 1:12? 1:12, madam. There is the manual. That is that page 45. Right. Qualified candidates is a exam. The number of advertising vacancies or what is this examination here? Preliminary. This is an examination that is conducted only when there are large number of candidates. The selection process basically starts with the examination. My previous is now, my lord, because of the segregation of posts, for these 3 posts, the civil engineers and the preliminary stages has, my lord, been deprived of competing for these 3 posts. 3 departments. That is, my lord, hydropower development department, development department, and water source department. Not even overall candidates are now. But as per the advertisement, we are qualified. The civil engineer can opt for water resource department, hydropower, there was art studio. And the preliminary stage already. So you are interested for which posts? My lord, then after the written examination, when the written examination conducted, which were options, man. So how does it otherwise affect? Because now I can participate only for 100. The chances of appointment, my lord, in 34 posts are put out. And they already put out. They put me out. The advertisement does not reflect anything. That 34 posts. That there will be a segregation of. And it's only those who come in the merit. Selected program, get participated. In the main, my lord, I think of the selection process is not even started. It's a preliminary exam of preparing now. Yes, before the selection process, in the other, are you saying that if 136 posts are taken together into 12 times, you are included in the zone of consideration? Yeah, my lord, because I'm already in the other district. For the 4 departments, I'm already in it. But for the 34, my lord, they have done 360 who are already there with us. In the first place, they have been taken there. What is the meaning of first list? I don't, that is why, my lord, I don't know how they have done it. They could not have done it. The advertisement does not say so. My lord, the candidate makes me clear. As qualified into participate for the 7th movement. 7th department. Input 3 department. Can also participate. What is agriculture engineering? You are not qualified for that. But I am qualified for it. Civil engineering as well as agriculture are qualified. That is the whole demand. These 3 departments where this agriculture engineering engineers are also qualified, they are, they have made a separate list. That includes 362
who are also in the department. When before the written examination, 843 minor civil engineering candidates who have in fact otherwise qualified for the other four departments are minor prior for even offering their candidature for three departments. Minor in the advertisement there is nothing.
Yes, Mr. Raman, why segregation?
It's very simple, Lordship. As per requisition, Secretary RWD, they make the requisition wherein the RR for this RWD, the education qualification required is Bachelor in Civil and Agricultural Engineering. That is the point. Then for WRT, education requirement is Bachelor of Engineering and Technology in Civil and Agriculture. So, and for Department of Hydropower Development, the qualification is Bachelor of Engineering, then Technology in Civil, Agriculture, or equivalent degree from a recognized university.
There's no quarrel. Civil and
That's why, Lordship. That's why this all the departments they are having different required qualification. Now, in case of this table 2, where 34 34 posts, for 34 posts, the required qualification will be different. Now, here, what is common is civil engineering. Civil engineering is common qualification for table 1 as well as table 2. And all 7 departments, EWD, civil engineering are qualified. But for these 34 posts, civil plus those agricultural engineering is required. Now, if in earlier days, this advertisement would have been advertised in 2 advertisements, 2 different advertisements. But as because it's a common, it has become a single advertisement. Now, out of that single advertisement, those whosoever have opted and those who are having the qualifications, common merit list is drawn out, sort out. Now, if that is why, if it was a separate advertisement, and separate examination, then those candidates who were topper in first table also would have been the topper in the second table. That is what we have taken. Now, since it's a common test, table 1 topper is qualified for table 1 and also for table 2 because they are having the requisite qualifications for both the departments. That's why these 2 names are appearing in both the departments. And why the ratio is ratio different.
How do you segregate agricultural engineering from there? In the ratio of 1.
Lordship,
You are saying that it's first 1, 4, civil 1 to 4, civil engineering. No other qualification. 5, 6, and 7, civil engineering and agricultural.
Yes.
So therefore, you have also considered but not in 1-4
Yes.
be a part of 5-6-7 so far as civil engineering is concerned.
Yes.
Now, how they have you included agriculture?
Agricultural engineering will not be qualified in table 1.
Correct. But for table 2, they are qualified.
Yes.
So how have you considered the ratio of 1:12?
That will depend on the
But it is
merit.
one common exam.
Yes. From the merit. From merit. From merit, there will be single merit list. Out of that, first, those who are in the for civil post, that is table 1, sorted out. Again, for civil table 2, it will be sorted out again from upper to last. And then those who qualified in table 1 is because the ratio is more. Ratio is more because post is more. And in table 2,
No. You are saying that both for civil engineering and agricultural engineering, something different. One common paper.
yes,
For all.
yes,
So therefore, one cutoff mark or one whatever marking.
no cutoff mark in prelims, no cutoff mark.
All right. So you are going simply by merit.
Yes,
Now, if you are going simply by merit, merit then need to segregate these.
needs to be
Why?
because in first civil engineering, first table nursing, those candidates, this agricultural engineering will not be qualified. That
Not qualified, but you're giving the same paper. Forget the first part. You're talking about the second part. For the second part, agricultural engineering is qualified. But they're appearing for the same paper with civil engineering is also appearing.
civil engineering will be very called table 2 also. Table 2 also. But
Let us leave table 1 for the time being. Let us focus on table 2. Now table has got criteria, qualification, civil engineering, agriculture. But the papers are same.
Lordship, I'm told that it's a separate question paper. I'm sorry. Therefore, Lordship, ratio has been
Separate question paper means for civil engineering also you are having a separate question paper or you are having the same question paper as in paper 1?
civil
Same. So if it is same, then why are you segregating the civil engineering? How are you combining these question papers that different? How are you? See, civil engineering question paper is different. There has to be a different merit list. Agricultural engineering is different. There has to be a different merit list.
Yes.
How are you selecting the combined merit?
My instruction was that there's a common merit.
How can there be common merit when there are two?
Lordship, and then I made it my affidavit, Lordship, what they have stated. Paragraph 7.
So in 88,
Yes, basically.
yes.
With regards to the statement made in paragraph 7 of the requisition, the answering opponent begs to state that the National Engineering Service Examination 2025 is a common examination to recruit assistant engineers in various work departments under the Government of National Pradesh. The requirement of this department and eligibility condition of post vary as per the nature of the duties and responsibilities of the respective departments. Therefore, even though it is a common examination, the Commission is required to prepare separate merit list for each department as per eligibility condition, education qualification received from the requisitioning departments. Now, therefore,
This is after the, this is in the preliminary exam.
yes,
This is the preliminary. Therefore, segregation made department-wise is required because of different eligibility conditions and hence inevitable. So,
No,
if,
but
you if,
it doesn't explain table 2.
if my explanation is not very clear, we can have our officer here, CCD, to explain that. Well,
When you are the learned counsel, then you have
sometimes-
not understood your officer.
Lordship,
How do you expect us?
Lordship, sometimes your receiver do not
address the bar as learned?
Lordship,
Not
in
for
the receiving end, Lordship, the receiver is malfunction. Sometimes
Not at all.
fails to receive. Any other? Further.
This adds to a further confusion now. If you have separate merit lists or different departments, how are you handling serial 4, 5, 6 or 5, 6, 7? Because each department has two branch stream, agriculture and civil engineering. Papers are different. How can you have a common merit list?
Further, to have further understanding and better perspective on the issue, may be pertinent to refer to the eligibility criteria as specified in the advertisement issued by the answering deponent, wherein 102 number of posts inclusive of 4 number of posts reserved for people, the person with benchmark disability, PWD candidates, that is 98 plus 4 equal to 102, are reserved exclusively for candidates having civil engineering degree under the departments of number 1, PWD, Public Health Engineering and Water Supply, Urban Development, and Urban Local Bodies. To fill up the above mentioned vacancies, no candidate other than those possessing a degree in civil engineering could be shortlisted. Further, as per the para 11C of the Arunachal Pradesh Public Service Commission FPSC manual for conduct of examination 2024, the ratio prescribed is 1:12, or as desired by the Commission. However, in general, 1:12 ratio of the vacancies is followed by the Commission. Therefore, applying the said ratio, the number of shortlisted candidates is 105, inclusive of PWD candidates. It may be stated that stated here that there were insufficient number of PWD applicants in specific categories against the total number of posts reserved for them. Hence, this in fact the total number of candidates to be shortlisted for written examination as per the said ratio. Therefore, there is no representation of the ratio in that case. That as regards the second issue is concerned, it is to state that as per eligibility criteria, candidates having a degree either in civil engineering or agricultural engineering are eligible to appear in examination against 34. So this is the answer. Against
Then you come to page 90,
this.
first sub-para.
Yes. Therefore, separate merit list combining civil engineering and agricultural engineering candidate has to appear in case of above 3 departments view of eligibility criteria prescribed for this post. Since it is a combined merit list, the candidates possessing degree in civil engineering.
But how are you preparing a combined merit? That is what I don't understand, because it is one examination. Had it been a separate paper for these 5, 6, 7, then you combine, then you may have a combined merit list, I don't know. May have a combined merit list. But if you are lifting candidates from 1 to 4 civil engineers in terms of the markings, and then agricultural engineering separately, and then making a combined merit list, then NFSC appears to be malicious. Allow them to appear for the examination. But they're subject to outcome of the petition. We are not saying that they will be selected, but well out to appear. Once you decide, assuming they're selected also, if the petition gets dismissed, then they will have no right to take for appointment. But in view of the examination just round the corner, and it be 3 months later.
Because at this point, can I have at least till tomorrow, clarify this one.
Tomorrow. Maybe. So let him understand, let him explain, let us understand what that is. What they have done in
The question raised by the
362, what the best of merit. And matter that they have, that is how they have. So they have taken the merit list from 102 posts. Serial. Then agricultural engineering separately. And then for this 5, 6, 7 posts, you have prepared a merit list separately, I think. Yes. 34 posts. Years to be sure. But if it is a single merit list, then you have to explain how you are combining civil engineering, agricultural engineering, and putting the same merit. Further hearing is tomorrow. Item 22. Item 24.
one petition lordship will not file.
So it's for the
It will have cascading effects. This petition will have cascading. The last petition that was filed, then they say that as per information, we have this marks scored, whereas commission will not issue marks. Issue marks until and unless the result is declared. So that environment
point it out tomorrow. Right. Point it out tomorrow. We are only trying to balance the equity. Then in the event they are allowed to appear without any with a rider, then any further claim will be subject to the outcome of the orders passed. In any case, will be entering the examination. No, even if you are allowed, we find that there is no infirmity in the ratio. You're getting your successfully clearing the preliminary or fine mains exam don't have no effect.
Item number 7.
Yes. Your file.
Yes. Why not it is better here separate the order of the commissioner suffer from first thing otherwise it is by asking is not asked by Friday. Of no use because the order has already been communicated to the chief secretary, learned chief secretary. Now it is for the learned chief secretary initiate the action.
All right. When is the matter fixed? Next date?
4th November.
4th November. Okay. Who's appearing for the respondents? Who's the respondent to? Information Commission. So you have fixed the next date on 4th November. He has filed some application.
So, my lord, in fact, my lord, he was supposed to file an application in terms of my lord's observation, my lord.
That application is filed. Serve the copy. Have you served the copy?
Yes. That is the application filed for the commission.
Page number 50. Section 1 of the edition.
My lord, on 4th November, by the, by order dated 31st July, the commission has sought action taken report within 1 month. Difficulty, even if this matter taken up on 4th November,
We
By
will look up to that. Mr. Yeah, this application is to have been filed.
Yes.
So we will direct the commission to address this and pass appropriate orders. And in the next day, we are saying direction for initiating department. Right? And then you intimate before the court after 4th November what is the statement. Yes. If the order stand recalled or proceeding is closed, you can close the. Okay. Any objection? Third, council parties. Reference order 95. The petitioner has filed an application on 30 August 2025 for. Sorry, when did you file it? 29. Yes. 29/8/2025 for Arunachal Pradesh Information Commission, Karnataka. Praying for the call of order 8/17/95. Memo number 2. Is submitted that the next matter is on 4th of November. Slow. Commission may consider the application filed and pass appropriate orders. If such orders are passed, this board be apprised of the next things. Accordingly, since the application has already been filed, recall of order issuance passed by the commission and next thing. So, the 4th of November, this matter being listed on 17th of November. And the next thing. Where is the order of the commission?
At page 60, this case, my lord.
this case may
Page 60 is the direction, serial number
16.
60, my lord.
60.
petition it is
Ah.
47.
47.
Yes.
In the next page, the directions contain at serial number 12 of the order dated 31st of July, passed by the State Proportion directing the Chief Secretary Government of Arunachal Pradesh initiate disciplinary action as per the circumstances. Shall state. Based on 7.
Item number 8.
Please, Your Lordship. Your Lordship, here in this case, Your Lordship, I am serving as a postgraduate teacher in biology at Government High Secondary School, Bajarline, Sepa, Your Lordship. Your Lordship, I have approached before this Honorable Court, invoking its jurisdiction under Article 2 to 6 of the Constitution of India, not by choice, Your Lordship, by compulsion, Your Lordship. Here in this case, Your Lordship, because of lawful transfer order has been issued by the director of school secondary on dated 2nd June 2025. Lordship, might kindly come to the page number 11, Your Lordship. This is the transfer order, Your Lordship, serial number
Page number 11.
11. Your Lordship. My name is reflected in serial number 4, Your Lordship. Wherein the competent authority has issued has transferred me from Government High Secondary School, Bajarline, Sepa to Government High Secondary School, Doimik, Your Lordship.
Serial number.
Serial number 4, Your Lordship. This clearly established my right to be relieved and join a new place of posting.
You want to go and join.
Yes, Your Lordship.
The unique case. Most people don't want to go. Then you want to go and join.
Yes,
And your order, relieving order, releasing order has not been issued.
and not issued by the respondent number 2.
Mr. Counsel, this is a very unique case. You should act immediately. He wants to go and join. Then your officer is restraining him on the ground that there is no replacement.
Yes, my lord. My lord, only ground, my lord, this is a cross transfer, my lord. In place of respondent number petitioner, my lord, respondent number 3 is serial number 3, my lord, page 11, my lord. She is not been made as a party, my lord. 11, my lord. Serial number 3, my lord.
She doesn't have to be,
My lord, as first mover, my lord. She is the first mover. Unless she joined,
who has passed the order? This order is passed by your department.
my lord.
So it is for the department to ensure that she moves fast.
My lord,
Why are you, why do you want orders from the court directing serial 3 to move first?
my lord, that is why, my lord. That is why, my lord. This has been this first mover.
Is there any repetition filed by the serial 3?
My lord, as on today, not, my lord. Because, my lord, under what ground, my lord, this has been still not released, my lord. Because in some
You
cases,
get your instructions day after tomorrow,
my lord.
on Thursday. All right? Yes. You give him 2 extra copies for the writ petition.
What is my prayer is that, Your Lordship, what happened in this case, Your Lordship? My surrender has been held up by the department, Your Lordship. I have been released from the school on 4th of August, Your Lordship. And moreover, Your Lordship, in every district, Your Lordship, they collect a attendance and performance report from the school of its jurisdiction, Your Lordship. In my case, Your Lordship, since I have been released from the school, so therefore my salary was held up.
And this serial number 3 is still there in
Doipok, man.
in Doipo.
Yes, my lord.
And she has not vacated.
My lord, not. So, and only after she released, my lord, she joined them, then only he can be released, my lord.
But you are the department, you have passed an order. Are you not anxious that your orders have not been complied with?
My lord, that is why, my lord, I have to examine this.
Get your instructions on Thursday.
My Lord, in page number 13, one WP message was also issued to all the DPSC and the headmaster, principal and the headmaster of the district unit.
Yes. Heard Council Commissioner. Let's look down. Responded. Commissioner scored the direction. Respondent number 2.
Yes.
Respondent number. Name B. Deputy Director Civil Education. Bracket B D S. Record is coming. District SEPA. For not issuing the peace order, in pursuance to the order dated 2nd of June 2025, whereby the petitioner, along with others, were transferred the former transfer order. So, the petitioner is presently serving as a postgraduate teacher for the subject of biology in GHSS Bazar Line, SEPA, East Cumming District. And she has been transferred and posted to GHSS, Government Higher Secondary School.
Yes.
Government Higher Secondary School, Bimbo, Pakpare District. By the said order, the person named at serial number 3 above the petitioner, namely 1 Ita Anie Echi, is also serving as a PTT biology teacher in GHSS Pakpare District, which was the petitioner had been transferred, was required to move first. So, be it as it may, the petitioner, although joined his or her his new place of posting, he has not been allowed to so as his reliever, namely Srita Ania Echi, has not been the post in which the petitioner is required to post, and reported in its present place of posting, namely Government Higher Secondary Bazar like SEPA East Cumming District. So the further claim of the petitioner is that because of not joining in the new place of posting, the salary of the petitioner has been better. So therefore submits that appropriate orders be issued by the board direct respondent. Is the petitioner, the council of the petitioner further submits that there is already a review order issued by the principal GHSS, like SEPA, ID communication dated 4th of August 2025. Therefore, his salary now will have to be seen from place of posting, namely GHSS going public money district. So, the standing council for the education department, it's permitted to complete the instructions. So why the by the next week, get this kind of extra copies served on the council for the education during the course of the
Item number 9.
Of solution in the acquisition of land.
We'll issue notice at this stage.
Yes.
Yeah.
Question on the because after so many years is approaching. When was the acquisition done?
All right. I don't think you're Mr. Nabam.
Esquire.
Sorry.
Esquire.
Sorry. Council for the petitioner and Mr. Ratan, the petitioner, by not bringing out the solution amount for portion of land acquired by the state. So, take no decision we can do 4 weeks. Mr. Ratan appears for respondent 1 and 3,
1 and 2.
1 and 3.
3.
Respondent 3, Mr. Arsoki. Respondent 4, Margaret.
Also, I'm appearing on behalf of the AGI, Mr. Respondent 4.
On behalf of
Mr. Kato, DHCI Mr. Kato.
Mr. So and so, on behalf of Mr. N. Kato, DHCI, the respondent, the representative, see the way next level. Each respondent five also there. Five. In item number nine, there is no five. Is there any respondent five here? Making the proposal.
Item number 10, 11, 12, 13, 14, and 18. They are similar.
Then 9, 10, 11, 12, 13, 14,
And 18.
and 18 are all similar. Same concept. No matter. 9, 10, and 11. It's for solution. And others, it's against the power grid, madam. They are asking solution in that, whereas it is not under the this right to get. That's also the mechanism on the submission made by the other edition of the question of maintenance we can step to the side of the type.
We have not received copy for item number 9 and 14.
Yes, Mr. Counsel, please. Your service of copies.
Sir.
Mr. Copinan, but nine.
Item number 15.
Now, generated and period. Before you. The next one, the appointment of the petitioners. We have the one even account is yes, first account exam as seniority. But if in here after the other by proposal from the among the engineer of the who have done 8 years of regular service and paid and passed account exam as senior. If the RR the engineer eligible to position the next higher post that is assistant engineer. Now the directly collect the NOC. And submitted
When in terms of this amendment, when did you become qualified?
I qualified in
No DPC was held.
no DPC was in there. Maybe kindly pay 112. You know the departments. 112. And it's a Roman.
Yes.
Okay. The DPC for proportion of India, eight posts are pending since last 4 years. In this regard, it is said that many stated they are paid for conducting DPC that is on the so and 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 so. But what the DPC has been postponed due to unable circumstances or technical reasons.
then they fixed the DPC, but they have not conducted it. Then what if you already defining the page? I challenge the page 01 is the DPC. Either the DPC meeting was held on 7/8/2024 at 20 hours in the office chamber of the consider promotion of the delegate year in the urban development. However, the following we are present in the situation where the DPC was informed that the following are the vacancy of the assistant engineer civil urban development and housing department. One, the resulting vacancy on promotion to DE on 9/5/11. Post created number 21/11/17/31. Total is 33. The DPC was informed that as per the assistant Indian recruitment rule 38, the faculty are to be filled up by promoting from who have completed 8 years of continuous service in the grade on the basis of selection from the officer. The reservation policy, the proportion is considered in the ratio of 50-50 as per the code of 100-point roster for reserved and unreserved candidates. The DPC took note of the benchmark for the performance record in the for the last 5 years in the respect of officer grade as very good to consider as fit for promotion. The DPC was also seen in the 100-point roster, notified interest vigilance clearance certificate and qualified 10 of service what account in a partner. After taking the grading report in the upper that benchmark spec for the promotion and so on the record department from the has recommended the promotion of the following to the post of assistant engineer and the which effect from 7/8 to 8/4. So here the year because you know that they are working as assistant engineer. Then from 2017.
So you want your promotion with effect from the date?
The date of from the eligibility of the land of service.
Let us issue notice at this date. Third, assistant engineer. Have been given with effect from date. Decreasing my notes. From which date you are given?
Then given your the 22/1/2018.
Effect from 21/2018. Commissioners have been long rendering their services on ad hoc basis. Satisfy the requirement which is having rendered 8 years of service successfully clearing the council examination and being able to present the fine. And I should know this is it's all. 1, 2, 3. 1. There are 1. Eight other extra steps of respondents 5, 6, 7, 8, 9, 9. By which it goes to you want to take dusty service on them?
Separate.
Date of recommendation is 7. 7, 8. 7, 8. Yes.
Item number 16.
Malat, in this case, Malat, we are appointed by the department but on administrative exigency, Malat. Thereafter, Malat, our service were regularized by the Department of Rural Development, Malat, RWD, Malat. And thereafter, Malat, when we are serving, Malat, we're rendering our service, Malat, on administrative exigency as per the requirement of department, Malat. There was a allegation, Malat, there's an inquiry that our appointment was not done through advertisement, Malat. On the basis of this, Malat, as I see, they have conducted inquiry. Page 31, Malat, inquiry was conducted, Malat, although our service was regularized. That inquiry, Malat, at finding a recommendation, page 40, Malat.
It should not be extended further.
Yes, Malat. Now, my responsible submission, Malat, should not be recommended, should not be extended further, Malat, whereas we have already been regularized, Malat. In my respectful submission, Malat, even if, Malat, this,
Where is your regularization order?
Malat, Malat, see at page 28, Malat.
It's 28.
Malat. So, DPC, Malat, 28, 29, Malat, and 30, Malat. And
28.
28, 29, 30, Malat. This is our regulation. Now,
We'll issue notice at this stage.
Malat.
Mr. Counsel,
Yes, I have for 1, 3, and 4.
the Adjournment Counsel. The petitioners are presently serving as JE
Yes, Malat.
within bracket ABCH under the RWD or Arunachal Pradesh. So the petitioner will initiate
J as well as Malat, draftsman.
the petitioner number given
1
the
and 2
name,
is J, Malat.
1 and 2 JE. And number 3
3
is
is draftsman.
draftsman.
Draftsman 3.
The petitioners and earlier in serving in officiating capacity and subsequently their appointments regularized on 5th of August 2021. Respect to petitioner number 1 and 27th of January. Respect to three. The council basis of some complaint raised by some quarters, inquiry was conducted by the vigilance department and subsequently the vigilance department intimated the secretary RWD government of Arunachal Pradesh by communication dated 10th of 2025 that the writ petitioner's initial appointment being on officiating basis in spite of being appointed, they have continued for several years. And his appointment was made without any advertisement.
Madam. Yes, sir.
Accordingly, Competition Authority was indicated not to extend their contracts further and to submit a compliance report. So, pursuant to the communication dated 10th 2025, issued by the Deputy Defense Secretary Adam, the superintending engineer, the bracket CO coordination. RWB, Arunachal Pradesh, was directed by the Secretary RWB Government of Arunachal Pradesh to ensure that the contracts of the commissioners are not to be extended further, and a compliance report was directed to serve. This communication was addressed on 26/2025. Housing to the Commission submits that these two communications are unwarranted and have been issued on about purported inquiries, the reports of which have never been served on the Commission. So, submit that by earlier already the 6th of August 2021 and 7th of January, but the Commission has all the commissioners. Therefore, there is a strong apprehension that pursuant orders passed by the Country Secretary Vigilance and Under Secretary RWB, the respondent authorities may take steps to charge the commissioners without following the process of law. State, considering some this for
One, three, and four.
1, 3. Since the respondents are represented on single page, so copy additional agreement 1, 8. Since the petitioners have already been regularized by the orders dated 5th of August and 27th of January, no coercive action taken by the respondents in respect of their services without whether leave or the
Item number 17.
May I please, Lordship? Lordship, this is a matter pertaining to premature transparent posting. Premature transparent posting.
Transparent.
Yes, being dictated by under the dictation of MLA. Lordship, presently, I am serving as an executive engineer, electrical division, Kurongkume district, Arunachal Pradesh. As per this order issued dated 20 September 2022, Annexure 1, page 20. However, I have taken over the charges of executive engineer on 20th February 2024 only. Transfer order was issued on 20 September 2023, but I have taken over the charges on 28th February 2024. Since then, I'm discharging my duty utmost sincere. And very unfortunately, Annexure 2, page 24. Serial number 7 is my name. I have been transferred from Kurongkume district to Longdik. Very surprisingly, within the normal tenure of 2 years, I'm serving there at Kurongkume since 2024, 28th February 2024. Now 1 year, 5 months only.
No. When is your first order of transfer to the present place of posting? It's Annexure 1.
Annexure 1, yes, Lordship. Yes. Serial number 5.
Transfer from TPMZ. What is TPMZ?
Transmission Planning and Monitoring Zone.
And you are posted in Sangram.
Sangram, Kurongkume district.
This was on 20th of September 2020.
Yes, but then I have been I have taken over the charges only on 20th February 2024. This is page 22, Lordship.
Why so? Why the delay of 1 year?
That's charges was not given to me. So finally on 20th February 24, I have taken over the charge.
Yes, who's for the respondent?
And
He transferred him on the
this is annexure 4.
note of the
Yes,
MLA.
yes. Annexure 4, page 27.
Yes.
Here, second forum. Till the transfer of regular executive engineer electrical, the senior most assistant engineer may be allowed to look after the functionaries of the Sangram Electrical Division. It seems that
But why is he initiating the note regarding transfer?
Yes, local MLA.
Why does he dislike the position?
What's your method? What did I make it stuck? Now, situation melody, he has been released, my daughter.
You have been released.
till now I am unaware of that releasing order.
Where is the order?
Still I am discharging the post of executive engineer. Because there is no any reliever to whom I have to give the charges. Still I am discharging as an
You have
executive
to
engineer.
give it to the next man available. Senior most surveyor. Senior most surveyor is what? Extending it.
It's equivalent to my daughter, AE, my daughter.
Equivalent to JE.
AE, my daughter.
JE.
Just,
Have a look at the release order.
No, I do not know.
No, you have a look. Give him a copy.
This was this order issued yesterday only.
Yes, sir.
Before that, I have filing. During the filing of that this present date petition,
But get instructions heard by the council to the party. This petition is filed with the petition, agreed by the transfer of the petition by the order dated where is the order of transfer?
24.
lecture 2, page number 2.
Whereby the petitioner is sought to be transferred from its present place of posting, which is executive engineer, electrical engineer, and posted to executive engineer, long-term electrical engineer. So, the council petition supports that this transfer order will be issued effectively after 1 year. Joining of the petitioner pursuant to the earlier transfer order issued on 0 September 2020. So, the council supports that this transfer order initiated by the local MLA and by note dated 12/2025, which council stop the council supports that transfer initiated by the department and rest of the submitted that. So, 1985 should write superintendent the bracket AP electrical circle 5. Whereby petitioner is to be in pursuant to transfer of the data. And the person who's supposed to join him has not joined.
No relevant. Their intention is just to accommodate his own choice of that officer, that is subordinate officer. Intention is very clear, crystal clear. And the Lordship, I have annexure number to page 26. I already served out there at the Longding. That is 2016 to 2018.
Submits that the reason for the petitioner they transferred out to his presentation posting. It's to a namely, what is his name? Senior most surveyor.
Maybe.
You don't know, but you are making
No.
assumption.
They are pressurizing like anything.
The persons considered favorable under such circumstances.
And Lordship,
But you have been released yesterday.
no, I am very much unaware. Lordship, I have already approached report of authority concern also by way of submitting that representation. That is
The
annexure point.
council has already given reconsideration of the order passed. Where is that representation?
Representation is annexure 5, page 36.
6.
Yes, Lordship.
This representation was filed on 30th of August, by which the petitioner had validated the council signatory power regarding the transfer of so
And Lordship,
yes,
as per official order that is 19 December 2008, the tenure of that particular officer is 2 years. Within 2 years, that particular officer can stay in same place of posting. This is annexure 6, page 37. This guideline has been violated.
the council for the so as per the office order issued by the office of the chief secretary by the order dated 19 December 2008, the tenure of posting of all government servants shall be 3 years. 3 years. Therefore, though we shall therefore we submitted the notice.
20th February 2024.
February 24.
Yes.
Therefore, its tenure of is not able. We heard council to practice. It is seen that the transfer, the petitioner appears to have been initiated by the local committee, by you or no. So that apart, by the transfer order, again, 8th of August 2025, the petitioner on being transferred was required to be briefed by the officer whose name is also mentioned here.
Similar case, I have citation.
The submission of the council that deliver is yet going, and as of date, he is not handed over the charge. Stop the conviction, however, is disputed by the government. For the government,
Right.
government to be that
Extending counsel.
standing counsel for
Power department.
power demand that petitioners will be released by the office holder dated 1st of September 2025. So, be it as it may, see that petitioner has already prepared an application before the secretary power by this petition dated 20th August 2025. So, under such circumstances, can be staged by direct executive power. Dispose of the representation by the and pass a speaking order by taking into consideration the policies and the guidelines that the council has a petition by the state. So, the department with the secretary power will also examine the claims or the grievances of the regulation of regulated by the transfer effected by the order dated 4th of August 20th of August 2025 was issued in public interest. So, any order that is passed by the secretary power pursuant to the directions issued by the board of thereof shall serve the regulation. That is exercise to be completed within how much time will be required? 4 weeks from the date of receipt of a certificate. And if such an order is passed by the secretary as directed above, the interim transfer order insofar as the petitioner is concerned, as well as the release order, is taken to we'll come back second half.
Pass over matter item number 3 and 4.
Worship, instruction was so.
Was in earlier for advertisement. Here, the key proof is all of 5 proof are undetermined. And we did now looking it is visual notification. Earlier, but when you come to the page 20, the internal page is given in the down below. Page 20. The relevant is order. final result post of Pharmacist allopathy. Present case pertaining to this very particular. Kindly come to the next page, next page. Out of 24, this again, I'm taking also the internet page to second. Closely will find just down below on the top closing. 127 posts have been filled. One post vacant could not be filled due to unable eligible candidates. The one post left is meant for the APST role, not the unreserved role. Whereas the present case is pertaining to the unreserved role. And how the 5 posts have been filled out. Then kindly come back to the page. For the top lawship from serial number 1 to 5, these are meant for the unreserved role. And the candidates who were lawship on merit, they have occupied this seat. So therefore, lawship, in the present advertisement, it doesn't include the lawship one seat of unreserved, which the present petition is claiming.
Lordship, in the Lordship will see in my writ petition, Lordship, earlier writ petition 329 of 2025. Page number 98, Lordship. The same
98 of the earlier.
earlier. Lordship will see the as per the merit, Lordship. Number 1 is Tenzing Sampal Sermu, Lordship. Total marks is 155, Lordship, 0.5.
So according to you, you have scored 159.
Lordship, I'm
Unreserved.
unreserved, Lordship. I hope to have been in the top, Lordship. Number 1, Lordship.
Except for some whether this particular advertisement is wanted and the job was left out earlier. Then was the one.
But this particular result sheet is already enclosed to the report.
Yes, Lord.
Yes.
So,
For some reason, we have
so what reason? That's the reason he appears to be have scored the highest marks.
Exactly.
That's like the biggest one.
That also has been clarified.
Yeah, but also on that issue though.
Ah.
Why they have been selected? Main part was have been filing. Yeah, the first thing. Just I am
So the last man to go up, the unreserved, serial number 5. If his marks are what he says, 159, he ought to have been at the top. He was at the top, then the last man will have to move out.
correct. Therefore, on that issue also, that's a first situation. I'm filing it.
In the first report, what is the challenge made in the first report?
That we should have been selected.
Then why the second repetition?
Because new base advertisement issue. Base advertisement. Well, one another post. My pen is claiming that this is the post which was left.
No, Lordship, I am not claiming that way, Lordship.
Then
What is your
case?
what is your claim in the present report?
Present writ petition, Lordship. Here, again, they have advertised six posts, Lordship.
Where is the advertisement?
Lordship will find our exact post at page 14 of my in writ petition 401, Lordship. Page 14.
Lordship will see post court number 42/25, Lordship. Pharmacist, LOPT, Lordship. Now there they have advertised in total, Lordship, six posts. 5 reserved for APST and 1 post unreserved, Lordship. Now, my humble prayer is, Lordship, till disposal of date petition number 329, Lordship, this post should not be filled. Why?
This is a subsequent selection. This is a subsequent application.
Lordship.
For this, how will the appointment be made by way of selection, examination? You have not applied for this post.
This post, Lordship, recently they have advertised.
Or you be selected or appointed in this post must appear in the examination selection process. Your non-selection in the earlier process, even if it was held to be bad, it's not entitled to get a post in subsequent selection without appearing for
Lordship, in this particular petition, our contention was, Lordship, since I was not filled in previous selection process.
If you are not filled, you have to challenge the last man. The last man who's there with his result sheet for last year. When was it published?
On 5th of
No. The earlier result sheet is 28 February. So there you have to challenge the appointment of the last man. Page number 20, page number 21 if you have. You will have to challenge the appointment of one person there. Think that you have got 159, the highest. Then if you are accommodated, this number 5 will go up.
another one has been included about. The other one has been
Somebody else.
one
Or number 1.
one is
All right. Because according to him, he's got the highest mark.
So he has to move back.
the first repeat.
You have filed your counter.
Okay,
Complete it.
and second repeat is yes,
All right, let it come together. But keeping one post vacant will not help you.
Lordship, if they are filing their affidavit, Lordship, as early as possible, we can dispose it of this.
Third, counsel. Both these petitions are listed together. Now.
Together, Lordship.
WPC 329. Challenge made by the petitioner is non-selection. Pursuant selection process undertaken for filling up the 5 posts of pharmacists locally in the unreserved category. So, according to the petitioner, higher than the person who's shown as in number 1, the unreserved category, securing 159. What is the marks you secure?
Lordship, mark sheet is at page 103, Lordship. Totaling, Lordship, will see that if we total
159.5
159.
as per the mark sheet released by the Arunachal Pradesh Staff Selection Board. So, in spite of that, the petitioner name did not appear in the final selection list. Being agreed, he has approached this court by filing state petition. So, the counsel for the respondent, Mr. S. Singh advocate, submits that the affidavit is under preparation. He'd like to file the which. So, then WBC 401, right? This restriction is sought for a direction to keep one post or advertised for unreserved category under the pharmacist allopathy, and subsequent advertisement issued by the Arunachal Staff Selection Board. By the advertisement dated 5/8. So this second petition is a sequel to the first on ground that since the petitioner, in spite of securing highest marks in the unreserved category, his services, he was not appointed. Therefore, subsequent advertisement, since there is one post shown for one post for the unreserved category, the petitioner is seeking direction. Respondents not selection appointment same post, same vacant. Consider petitioner's claim acceptable with direction the same post. Telling me that subsequently one of by some separate and subsequent issue by selection board where 5 posts of pharmacists and allopathy inter alia with other posts available have been advertised, writing applications for filling up these posts pursuant to the selection of the other. So, right, one post is kept for unreserved category.
Total is 6. 5 is
posts out of the 6. One post is reserved for unreserved category. Not by the same. Therefore, at this stage, no interim audit are called for PC number 401. However, the respondents have updated to 5-year affidavits and both the matter will be taken together again after 2 weeks on a date fixed by the ministry. And an attempt to be made by the yeah, it's yeah, what is it should have been IL also. File your application. Because you see, his claim really is in the person which you have to satisfy. First. Second writ petition, even if we dismiss it today, how does it solve your problem? You have to apprise the court why you have overlooked the candidature securing 159 marks. But that is the issue. To get instructions on that issue and sort it out.
So they are ready to file
If that writ petition gets disposed of, this has to be disposed. Yes.
Pending lawsuit, when this issue is not connected at all to the person,
To file your objection, we close the matter.
then that is their lawsuit. When apparently lawsuit see the prayer lawsuit.
We have seen it, but to file it, we have to ask. Notice, we have to hear on the matter. We are not issuing any interim orders there.
No, that is true, Lord.
Right. So, it is that your prayer that both the matters are connected together. On the last occasion, you submitted both the matters.
But whether this solution the most led by the other
Right, does not.
that was the only issue.
We have recorded, he is not applied. See on the next.
Let me withdraw my item number 4. My name is
Since item number 4, you filed an application before the registry. File it before the registry. Right. This number.
Item number 19.
powers under the act. The only thing under the there's a private. It's on the basis of this complaint matter by
It never appeared.
well, he appears, his name is shown here. Is the private respondent who is going to be affected. Otherwise, my instructions are also that Mr. Wrongly presumed to have liability.
Mr. He followed the council. And council require maybe something that private respondent 3 or 4 is represented by Mr. Tito. So considering the issues raised in the stand allowed, then private respondent stand effective under such circumstances. There, because it's not the next week. On 15th of September is a right now.
Item number 20.
Please, Your Lordship. Your Lordship, I'm appearing for the petitioner in this matter, Your Lordship. My Lords, in this petition, I have raised 2 grievances, my Lords. The first grievance pertains to the assessment period 2013-14 and 2014-15 of the AP, and I was assessed under the AP Goods Tax Act 2005, Your Lordship. So the first issue is regarding non-payment of statutory interest on the delayed payment of refund, Your Lordship. And the second issue is relating to the assessment period 2015-16, 2016-17 and 2017-18, where my refund application is not being processed for the last 3 years, my lords. My lords, with respect to the first issue regarding non-payment of statutory interest, if your lordships may kindly note certain dates, your lordship. On 17 September 2016, the assessment order was passed for the relevant assessment periods, your lordship, where a refund, where it was directed that I'm entitled to a refund of around 1 crore 84 lakhs, your lordship. That is at page 23, your lordship.
Where is the assessment order?
Assessment order is at page 23, your lordship. That is 17 September 2016. Your lordship has page 23, your lordship.
Yes.
And at page 25, your lordships will find, your lordship. If your lordships have page 25. And your lordships may see the end of the table, your lordship, excess tax paid for 2 years, 2013-14, 2014-15, which is coming to 1 crore 84 lakhs, Your Lordship. And then the last line, Your Lordship, accordingly, refundable amount arisen of rupees 1 crore 84 9,000 only. Thereafter, Your Lordship, if Your Lordships have page 26, Your Lordship, I filed my refund application on 7th October 2016. Your Lordships have page 26, Your Lordship.
Yes.
I say enclosed herewith Form FF09 along with relevant supporting for submission of the needful. And this is for the refund, Your Lordship, which was received by them, Your Lordships, has page 27. Page 27, Your Lordship. This was received by them on 14th October 2016. Now, thereafter, Your Lordship, my refund application was not processed, so I filed a writ petition before this Honorable Court, and Your Lordships may have the order passed in that writ petition at page 29, Your Lordship. And Your Lordships may have page 29, at page 30, Your Lordship may have para 3. The grievance of the petitioner is that they have paid a tax amount. Yes, Your Lordship.
Ultimate direction is at page 30.
31, para 4, my lords. So the direction pertains to the very same refund application, and they said that the refund has to be processed keeping in mind the provisions of section 40 and 44 of the AP Goods Tax Act. My lords, this is very important, my lords, because the statute interest arises under section 44, my lords. Thereafter, my lords may have page 32, my lords, because this payment was only made on 10th March 2023. This your lordship's order was 29 November 2021. Even after your lordship's order, this payment was made only on 10th March 2023, which is at page 32. And at page 34, your lordship may find that it shows this is the bank statement, my lords. And page 34, if your lordships may have, there's a date, my lords, credit of 1 crore 79. My lords, there's no item number, but 1, 2, 3.
Yes, we find it 10th of
Yes,
March.
my lords. Yes, my lords. 10th March, credit of 1 crore. So instead of 1 crore, instead of the refunded amount directed, they paid me 1 crore 79 lakhs. These facts are not disputed, my lords. Therefore, my lords, after a delay of 6.4 years from the date of receipt of my refund application, they have refunded the amount, the principal amount, only after a delay of 6.4 years. Now, if your lordships may see the AP Goods Tax Act 2005, my lords, section 40 subsection 3 says that within 1 month of the filing of the application, the refund has to be effected, my lords. So 14 November 2016 till 10th March 2023, my submission is that statute interest is liable to be paid.
Your pleadings? Is it enclosed to your pleadings?
My lord, section 44, I have produced. Section 40, subsection 3, I apologize, my lord, that has not been produced. But section 40, subsection 3, if I may be permitted to read, my lords, of the AP Goods Act. I have extracted section 44, my lords, which provides for
Is there
the...
no local counsel available? Is there no local counsel here?
My lords, he is also appearing. I really apologize for this, my lords. But
here.
if your lordships may permit me to read section 44, my lords, that is, I have extracted it in the petition, my lords. Lords, if my lords have the act, section 40 onwards deal with refunds, my lord. Section 40 onwards. My lords have section 40?
Yes.
My lord, section 40, if your lordships may have subsection 3. If I may read that, my lords. subject to subsection 4, any amount remaining after the application referred to in subsection 2, which is the application for refund, shall be at the election of the dealer either A, refunded to the person within 1 month after the date on which the return was furnished or claim was made for the refund, or carried forward to the next tax period as a tax credit in that period. 4, where the commissioner has, subsection 3 is relevant, my lords, because it has to be refunded to the person within 1 month after the date on which the return was furnished or claim was made for the refund. My claim was made on 7th October 2016, received by them on 14th October 2016, and therefore the refund was payable on 14th November 2016. Then your lordships may have section 44, my lords. This is admitted, my lords, that the refund was made only on 10th March 2023. Section 44 deals with interest, my lords. Para 1, a person entitled to a refund under this act shall be entitled to receive, in addition to the refund, simple interest at a rate not less than 6% per annum and not exceeding 12% per annum, as may be notified from time to time, computed on a daily basis from the later of the date that the refund was due to be paid to the person or the date that the overpaid amount was paid by the person until the date on which the refund is given. Because in this case, the later date is the refund was due to be paid to the person, which was 14th November 2016, your lordship, in this case. Then your lordship may have explanation 2. When a person is in default in making the payment of any tax, penalty or other amount due under this act, he shall, in addition to the amount assessed, be liable to pay simple interest on such amount at a rate not less than 20% and not. This is for the assessee, my lord, but for the delay in payment of the refund, it should not be less than 6% and not exceeding 12%. My lords, therefore, in light of the same, I made several representations after the payment of refund, my lords, which were not responded to. And the first representation was 31st October 23, your lordships, at page 35, where I calculated that 1 crore 37 lakhs approximately was payable from 14 November 2016 to 10th March 2023 at the rate of 12%, your lordship. So according to us, your lordship, there was a delay of 2,338 days, 6.4 years, from 14 November 2016 to 10th March 2023. And therefore, lordships, praying for a direction that this amount, the statutory interest, the amount of statutory interest may be directed to be paid, your lordship. And in fact, your lordship's order of 29 November 21 clearly stated that it should be passed in accordance with keeping in mind section 44 as well, your lordship. And in fact, rule 47 of the AP goods.
Was there a direction specifically issued by the court earlier?
My lords, if your lordship has the 29/11/21 order, there's no it says keep in mind section 44, which provides for statutory interest, my lords. There's no specific direction to that extent because it was subject to calculation laws. But page 31, if your lordships had, it says the form FF09 and pass a reasoned order thereon by taking note of the requirements of the provisions of section 40 and 44. Page 31. And the requirements of section 44 are payment of interest. Is
there any statutory body which is required? There is a tribunal. Regarding your claim of interest.
Yes, my lord.
You have submitted your applications before for which authority? The assessing officer?
My lords, the refund has been processed, my lords, by the assessing officer. But your lordship, my claim, which is of 31st October, the claim for interest, because your lordship, Rule 47 provides that in the refund order itself, they should also provide for the interest amount, which they failed to do. So therefore, Lord, 35, I made my application to Deputy Commissioner, Department of Tax and Excise, my lord.
There a tribunal here,
Sorry, my lord.
Mr. Rana. There an appellate tribunal here.
Appellate tribunal. So that I don't have to take instructions, my lord.
All right. Anyway, the mandate of the act says that they're entitled to some interest. So that needs to be addressed to by the authorities concerned. Where are the rules?
Rule
Madam
47
Counsel,
is a
you should have sent copies of these act and rules that you want to rely on, because you're
I apologize. I really apologize, my
video
lord.
conference and don't even have the assistance of a local counsel.
Would your lordship
Is
permit
there
me
no
to?
local counsel engaged in the matter?
Yes, my lords. The local council, his name is my lord R. Singha, my lords. If your lordship permits, I'll file the EP Goods Act rules, and there is one judgment of the Supreme Court also, your lordship, which says that statutory interest ought to be paid, and there's no discretion so far as statutory interest is concerned.
What is that judgment? You have the judgment with you now.
My lords, I have the citation, my lords. If your lordship permits, I'll file the acts and the judgment, my lords. I'm sorry, my lords, for this inconvenience. But if your lordship deems it fit,
By tomorrow?
yes, my lords. I'll file the
Take it up
acts.
day after. Take it up
Obliged,
day
my
after.
lord. Obliged, my lords.
Please again day after tomorrow. Bring the counsel for the petition. Case before the court, relevant act and the type. She would like to rely on. It's been based on 4th September.
Item number 21.
Yes, Mr. Rapang.
Proceed. We have proposed the record.
There was no served on the person who's independent.
Notice was there, Lordship. Notice. And the committee was formed. In the, yes. 8/1/2005. Committee was formed.
Is the committee issue any notice for the
Now, then, notice was issued by the,
to the petitioner?
yes,
Where is the notice?
page 103, Lordship. Page 103.
In this bunch?
Yes, Lordship. It's to set certain. In 103, so-called notice, dated 18/7/2025. 18/7.
open notice after that? Find a reply.
Yes,
Where would one find a reply?
I think that's in the, also in the picture.
I have accepted my
Where is that report of center in charge or somebody? Your order was likely.
Page 118. Page 120 may be seen, that's a petitioner's confession letter. Page 120. Undertaking. In undertaking, it says that I accept that I was in possession of mobile phone during the examination process, and I understand that I am liable for invalidation of my candidature for this exam and debarment from appearing in all future examinations conducted by APPSC or any actions as the APPSC may deem fit. That's undertaking. So
What are with the mobile phone person?
invigilator.
Invigilator. Where is the statement of the invigilator?
Page 150.
Yes, yes. Also clearly stated, Madam. Therefore, we have designed to our fate. We didn't.
Now, on the day she had appeared, she was appearing for
Preliminary exam.
preliminary exam. So, how many papers on that day?
Two papers.
Two papers. She appeared for the first half only.
The first half.
Then she was not allowed to appear in the second.
From thereafter.
Thereafter. And now your basic contention is that it amounts to double jeopardy.
Yes, Madam. On the same issue.
But you are not challenging the rules as such.
No, Madam. Because the rule provides for or. It is not N. But in my rebuttal, I'll come to that point also. But therefore, my lord, my basic submission is that this has to be either, not cumulative.
Say with the
Lordship. Now, rules.
there is one set of rules. Which is the 309. This is the examination rules.
Yes.
The Arunachal Pradesh Public Service Combined Competitive Examination. These rules Seven.
Yes.
7K.
K. Double 8.
A or B. This is of Rule 11K.
GK. K. 11K.
Definitely your subsequent guidelines appear to be important. The guideline.
Lordship.
So this Rule 11K, in sub-rule A and B, there is more.
Yes.
Whereas in the guideline, it is N.
Yes.
So in case of conflict between the 309 rule and the guideline,
Yes, I got. Now, my reading of Lordship 2019, this, my reading would be like my understanding of the rule. Now, Rule 11. Rule 11, let us see. A candidate is or has been declared by the Commission to be guilty of this. Now, here, a candidate who is or has, that let us delete this, a candidate who has been declared by the Commission to be guilty of. Now, then comes G. Will be guilty of using unfair means during the examination. Here, the word or is there. Or then using unfair means. Using unfair means during the examination. Or then comes key, K. Or here there is no ending of that very meaning.
So a person who has been caught with unfair means. Then comes K. K. Violating any of the instructions issued to the candidate. That is, instruction is given. We have met annexers also, and it is there in the admit card also. Issued to the candidates along with their admit card certificate, admission certificate. All letters permitting them to take examination or commission, or as the case may be, attempting the commission of all or any of these acts specified in the foregoing clauses by a candidate may, comma, in addition to, this is the word, in addition to rendering him liable for criminal prosecution, criminal prosecution be liable. That, yeah, it is not or, comma is there, Lordship. Comma is there, A. Then disqualification, then to be debarred permanently, or then by the state government or from any employment under them. And here again, if she or she is already in service, government disciplinary action under the relevant rules shall be instituted. Now, Lordship, if it was only for that department, then the necessity of all this ABCD was not. First, one has to be caught.
Have to be caught.
Yes,
You have to be guilty of anything between A to K.
Lordship.
Any violation of A to K. If you are caught doing that, more particularly K,
Lordship.
then in addition to rendering him liable for criminal proceedings, that's that. In addition, whatever else you may do, you will be disqualified from the examination which you are there, number one. Or you will be debarred permanently or for a specified person. Now the counsel for the petitioner's argument, if you have already invoked A by debarring the petitioner for that examination had appeared.
That was done as per the manual. Action against a candidate found adopting unfair means. So, 14A. When a candidate or any other person, including official on examination duty, caught guilty of misconduct or malpractice or any offences with evidence, he or she shall be removed from the examination hall room by the central superintendent in consultation with the observer.
These are the guidelines.
Yes, Becca.
Now these guidelines will have to flow from these rules. These guidelines, you will have to trace it to the rules.
Then Lordship, he has to select the
No.
and that time.
No. See, these are 309 rules. So it has the status of a statute.
Yeah.
So these cannot be triggered to be guidelines. 309 rules. Guidelines are essentially in a place to met the rules. Or maybe some clarifications necessary. But if these guidelines explain something more, provide something more, then it go over and above the rules that are already described. Let us attempt to read the rules as it stands. Rule 11.
Yes.
These are with regard to a person being declared guilty by the commission.
Not by the commission first.
Declared by the commission guilty of the following.
In 11.
11.
No, it's not. Yeah. A person who is or has been declared by the commission to guilty of So now he has not been declared by the commission. Throwing him hard out from the examination hall was not by the commission. It was by the invigilators. Support after that. Then once the commission is there or such action, then it is reported to the commission. Then commission will take action as per the report. So that is the what we understand.
No, but if commission must also authorize the debarring of the candidate from the rest of the examination. The invigilator being given the power is acting under these rules. So essentially the invigilator for that matter is representing the commission only. So all actions done by the invigilator are ratified by the commission.
So that's my lordship. The one is
So what? Where is that order of? Is there any order passed by debarring the candidate from that examination?
yes.
Where
No, that
is that order?
from that examination there was no department. Commission has not passed the order to that effect.
So who stopped her from appearing?
Lordship.
Who prevented her from appearing?
This one time. Yes, commission has ordered.
130.
One month base one time. 130.
So this
Yes.
one.
Then lordship. Police action is also there. And then our rules are also there.
Police action is over in addition to anything that you may do. Police action does not fall under AN. But police action is over AN. Even if you take A or B, you can still go for police action.
Our understanding is that now 11 wouldn't have been here if the action was taken on the spot. That shouldn't have been the meaning. So the purpose of and intent of this act will not be there. Now, this act is for action taken for those who commit mistakes in examination. That is the day of examination. So once that action mistake is done, then the action comes, FIR comes, then only this
entire effort of interpretation is because of one word, is or.
no, lordship, the or it's not. Lordship, to my understanding, or is not there, lordship. Now, lordship, again, I'm repeating, lordship. To me, but to my understanding, lordship, if I may read this, a candidate who has been declared by the Commission to be guilty of using unfair means during the examination, in examination, that is violating any of the instructions along with the admit card, may, in addition to rendering him liable to criminal prosecution, be liable. That is A, B, C, D. That's given. That is my understanding. Because in other thing or, but here it is not directly or.
So you are correct. In addition to criminal proceedings, be liable for ABCD.
Yes.
But ABCD, you can't do it all or in any combination. You have to do it only one. Either A or B or C.
Let us see. A candidate who has been declared by the Commission to be guilty of and let us forget about G or C. Let us give G one. K. State where a candidate who has been declared by the Commission to be guilty of violating any of the instructions issued to a candidate along with the admission certificate may, in addition, I'm coming straight away to may, in addition to rendering him liable to criminal prosecutor, be liable. Then comes A, be disqualified by the Commission from the examination for which he is a candidate. Or here one of the A, B, C is to be given. My understanding is that.
Only A or B.
Yes, A or B.
So you have already given A.
And Commission has passed only under B. Pass order under B. To be debarred permanently or for loss of specific. Commission has not passed under A, or C. No. We have passed, we have debarred him to appear in the second paper and this. To be debarred permanently or for a specific period.
When is the next, what exam you are anticipating or contemplating?
Main exam is on 6th and 7th.
Main. But you are not allowed to appear for preliminary second.
That's all.
You don't know. Yes. Then how do you appear for main?
That's why I'll issue my prayers.
Yeah.
Because there are two alternative prayers.
And missing line.
Yeah.
Now I have produced the action taken by the AC permanent department for 3 years, and the other one for Rajasthan for department for 5 years. And normally, Lordship, we have take all those guidelines from AC on.
Yes.
I have submitted my rebuttal and then the provision sheets also. But I'll just straight away read out my rebuttal. Lordship, what rebuttal? This one, rebuttal.
Yes, yes. I'm got it.
Just keep reading only, Madam.
Yes.
At the outset, it is respectfully submitted that the reliance placed by the respondents on Annexure 1, 2, and 4 of the opposition resolution is wholly misconceived. In as much as those documents pertain to the incident of 2024 examination, which is not under dispute. The petitioner has already accepted the cancellation of her candidature for the said 2024 examination and raised no further protest. The present challenge pertains only to the subsequent and additional penalty of 1 year debarment imposed by order number such as Annexure 12. Now, my lord, in the affidavit, my lord, during the argument, Mr. Rappang submitted that or and between. The submission is untenable. As a matter of settled law, quote unquote, or is ordinarily disjunctive and quote unquote and is conjunctive. They may be interchanged only where the statutory context makes that necessity unmistakable. Courts interpret but do not amend text to convert alternative consequences into cumulative ones. Leading
So going by your argument, as it appears, would be that supposing somebody is caught using unfair means, then the commission has to decide whether to debar him or her from the rest of the examination or impose a longer punishment. Now, if that interpretation is what the issue, then let us say in a given case, somebody is caught today and there are subsequent papers tomorrow and day after.
Therefore, my lord, in the guidelines, under clause 14.8, there are 4, 7, 8. There are around 10 sub clauses. This is, it prescribes how the invigilator will conduct once it is found, and how the Public Service Commission will be consulted, and how they will arrive at the decision. So,
but these things can be done at that moment.
That moment, my lord, the because the Public Service Commission is 100% at alert. They are all ready. So this matter is reported. The matter is taken up by the Public Service Commission immediately, and they convey the decision, and this decision is the A. And that is how this department order, the department is being affected.
So this decision was conveyed without putting into notice. First decision.
No, but what happened is, after that was found, I was taken to a separate room. We were there for hours together, because that was the time when Public Service Commission were consulted, because this under this provisions were consulted. They have taken a conscious decision based on the rules 2019. Your Lordship has correctly pointed out that this has to be, because this is the extension, replica of the A, this clause 14. So then that commission was always ready, members. So they had consulted amongst themselves. They have come to a definite decision and invoked the A, sub-rule A. Now, my lord, in the affidavit, they have also taken the stand of independent source of power and the issue of double jeopardy. My lord, this is upcoming, just this point. Commission's state, clause 14A of the manual is independent of 2019 rules. Since rules 2019 do not empower invigilators to remove candidates, such power flows only from 14A. Hence, subsequent action under Rule 11K A is distinct and no double jeopardy arises. This is the stand taken. But my rebuttal is clause 14A of the manual 2024 is not a stand-alone code. It is an executive order containing administrative instructions deriving its force from the parent rules 2019. Clause 14D, subclause 8 itself provides
quote unquote, further action against the candidate may be taken as per the rules. Quote close, unquote. This language conclusively establishes that the manual and the rules are integrally connected and not independent. The provisions of Rule 411KA is then incorporated into Clause 14A. Once Clause 14A was invoked and the petitioner's exam attempt was cancelled, the consequence under Rule 11KA is to exhausted. To impose a second penalty of debarment for the same imputation is wholly arbitrary and violative of Article 20 Article 2 of the Constitution of India, protection against double jeopardy, as well as the doctrine of proportionality. The submissions made by the Council of the APPSC that the word quote unquote or between Rule 11A and Rule 11KB should be taken as quote unquote and is wholly unjustified and misconceived. The Commission cannot artificially bifurcate one misconduct into two compartments merely to justify cumulative punishment. Both the cancellation of her attempt and the consequent one-year debarment stem from the same factual imputations, namely possession of a mobile phone. Hence, the punishment is duplicative and disproportionate. Two, Madam. On the characterization of Clause 14A as preventive, Madam. They have used the word is preventive. This was taken as only as a preventive, Madam. Commission stands. Removal under Clause 14A is merely preventive to maintain discipline and not punitive. My rebuttal is the removal under Clause 14A had the direct and substantive effect of cancelling the petitioner's examination attempt.
No, sorry, you are referring to where? Preventive where?
Page 3, Malot, serial number 2.
So what are you saying? That the respondent's argument is that
This action has been only taken as a preventive and it is not punitive. These are the steps taken in the affidavit. My rebuttal is the removal under Clause 14A had the direct and substantive effect of cancelling the petitioner's examination attempt and depriving her of the opportunity to compete. Such deprivation is inherently penal in nature. A measure that extinguishes a candidate's attempt cannot be reduced to a quote-unquote mere preventive step. It is a punishment in every sense. The subsequent one-year debarment, therefore, constitute a second penalty for the same misconduct. Number on requirement of hearing, the stand is written representation is sufficient. No oral hearing is required. This is the stand taken in the affidavit. My rebuttal is, while it is accepted that principle of natural justice can be satisfied by granting a written opportunity, but the minimum requirement is that the authority applies its mind and passes a reason-speaking order. The impugned order is non-speaking, mechanical, and passed without proper consideration of the petitioner's defense. The Commission has acted merely as a mouthpiece without exercising its independent judgment. Neither the committee nor the Commission has summoned and heard the petitioner in person. Your Lordship has perused the original records. Your Lordship, it has fallen out from Your Lordship that the petitioner was not been summoned by either the committee or the Commission. Any decision adopted was taken behind the back of the petitioner for her disadvantage. Such action offends the principle of fair play, reasoned decision making, and natural justice. But here, to end it, compassionate plea, the petitioner is a wheelchair-bound young woman from a humble background who has invested years of hard work preparing for this prestigious examination. The 2024 mishap was a solidarity inadvertent incident in the petitioner's entire academic and career pursuit. The impugned order of one-year debarment effectively extinguishes years of preparation and destroys her career prospect. While rules are indispensable for ensuring discipline. Their application must not be so harsh as to obliterate a young careers for one isolated lapse. A balance must be struck between discipline and proportionality. Well, here my prayer portion also I have also. Accordingly, it is prayed that this honorable court may be pleased to quash and set aside the impugned debarment order number such and such, that 24/7/2025, issued on such and such in excerpt 12. Confine the penalty, Malad. I concede, Malad. Confine the penalty, if any, to the forfeiture of examination attempt already cancelled in 2024.
So what examination are you contemplating now?
Malad, Arunachal Pradesh engineering service examinations.
When is it scheduled?
Malad, prelims. Today there are many cases, Lordship, for that.
So no, the examination, the preliminary examination which you had appeared for was for
That is for Arunachal Pradesh civil service examination. Malad, circle officer, DSP, and all this. This is only for the engineering, assistant engineers.
now this examination you intend to appear or
Yes,
you intend to appear?
yes, I intend to appear.
When is it scheduled?
6th and 7th September. But my submission is, but for that one inadvertent mistake, Malad, that it be confined to what already punishment I have suffered for the 2024. Malad, my submission of the reasons is, Malad, they should strike a balance between deterrence and compassion, Malad. Because on records only, I have admitted that I did, a mobile was found from me, and I did not, whatever the actions were taken, I did not protest. I have accepted my fate. Then, Malad, I did not cause any further, any deterrent activities.
Cannot because
Yes.
you're debarred already.
Yes, Malad. No, Malad, even I have not protested also, because that I have accepted. And I was preparing myself for the next examination. Then, Malad, to permit me in the exam to be held on 6th and 7th, or else, Malad, if at all it is not practically permissible, no, Malad, at least for the end of justice and fair play, this honorable court, being the epitome of justice, will pass an order keeping one seat vacant, conduct a special test for me for the exam.
See, that prayer is not acceptable for the simple reason that you have admitted that you have committed attempted or not, the guidelines say that these things should not be available. No mobile phones. Whether you use it, not intend to use it is irrelevant. The mobile phone was found, and that is a restricted item. And you admit.
But what I'm seeking is this present examination, not that earlier examination. That is gone.
Yeah, that is gone. That even if we want to, we can give it.
Yes, even the appointment letter, I think, has already been issued. So, Malad,
Gone. So, therefore, your prayer that one post should be kept vacant
in this present exam.
in this present, the
Yes.
civil service,
No, not civil service, engineering service.
engineering service. How the post will be kept vacant unless you are allowed to appear?
Or else, Malad,
Mr. Rapang,
government can be directed.
we permit her to appear, but the results you don't declare.
Yes, Malad.
Lordship,
Subject to orders of this court.
Lordship, the prelims already over.
So he says 6th and 7th.
No, but
No,
that is
that's for
mains.
Mains exam.
Then how will you appear without going for the prelim?
Malad, that is because I was deferred on this thing. And Malad, here in Malad,
I thought 6th and 7th were some separate exams, prelims or something. No. How will you appear in 6th and 7th if you don't appear in the games?
no, Malad,
That is why my submission is that once this department order, Annex 12, is held to be illegal and is watched, then the natural process has to follow.
Once we come to a finding that it is illegal, etc., whatever orders we pass to compensate, it's up to us. We decide. But there are many aspects, as I can see, which we'll have to deal with it, considering the submission, the government submission that both the councils have made. There are several issues. Interpretation of these clauses, whether personal hearing is contemplated, the privacy of the rules over the guidelines, etc. So it will require some hearing and detailed order, etc.
Therefore,
But we were concerned with the fact that since you mentioned 6 and 7,
mains.
yes, but then you can't appear in mains unless you clear the prelims. There's no time or there's no point now to direct the APSC to allow you to go or direct the APSC to go for another special drive for prelims, because you may succeed in prelims, you may not succeed in prelims. Where is the guarantee that you will clear the prelims?
Only one small submission is in page number 71 of my repetition in Excel 15. I have.
We'll give you liberty to file necessary application in the pendency of the repetition or any fresh examination that may be announced. Permit you to sit in the exam.
No, but let this Lordship.
So we have heard, but I
taken so much of time. Lordship.
Is there anything more to be submitted?
No, my lord. My lord, only one submission is that, my lord, to ensure that justice follows. My lord, at least if I am not allowed to sit in the 6 and 7 examination, my lord, a direction can also be made to the government to create a post and then allow me to compete there.
How can that get to that?
I leave it to your lordship, but then as I, with all compassion, standing here with a folded hand. Times along with legal rights, compassionate right?
Compassion is all right, but compassion doesn't make good law.
Yes,
Alone.
alone. But since I believe that privacy.
So this, even if we extend our compassion, how will you benefit by it? Tell us. You have not been able to clear the mains, I mean the prelims, because of this episode. So unless you clear the prelim, you can't be allowed to sit in the main.
So therefore, my lord,
unless we decide this matter,
yes,
finally, and as to whether you should be permitted to appear for main or things like that.
Well, that is why I leave it to your lordship, but with compassion, supported by law.
All right. Mr. Rapan, anything more, or these papers are meant for us?
No, lordship.
You are taking it back.
Yes, lordship.
Then
It's not required.
We don't know what is required because you have given us so many bundles of papers. Go through it first.
Ottoman style.
No, Hanuman style is okay, but we need to hunt the relevant papers from there.
Only one fact.
You can tie it up in a bunch and give it to us. Let us go through and once we pass the order. Whatever you think. Yes. You meant saying something.
Only to what that is that the order was issued by the commission, the initial 2024 order, and then during this hearing, I was not personally heard the question. That is very acceptable.
There are judgments you have not relied on this.
Have to note it down.
Like, give us a copy later, examine.
More or less.
Tomorrow only for this, or you want the further hearing?
No, we have other methods.
All right. Third, counsel for parties. You have filed your affidavit, Mr. Raman. Let us see how far we can go. All right, Mr.
Your Lordship, I'm appearing on behalf of respondent number 3.
Huh?
I'm appearing on behalf of respondent number 3.
Yes. What are you afraid?
Lordship, we are yet to file affidavit. Your Lordship, we filed our reply today.
Yes.
Yes, I'm for the petitioner also.
For filing. Not some.
You are for respondent 1 and 2. And you are appearing for respondent 3.
Respondent number 3.
Yes, what do you say?
Let them file affidavit and term it fixed on 20 to 10.
20 to 10.
Yes, Lordship. The council may go ahead with it.
Counsel. Counsel for respondent 1 and 2. 3 for further time. 5 their affidavit. Yeah. Counsel for respondent. Submits it. 5 your counter.
Yes, we filed our reply. They're supplying a copy to the petition.
5 the counter affidavit. Like to file you. Like?
Yes, required, Lordship.
It has agreed to take the matter. State on 22nd of October.
Yes, Lordship.
22nd of
A pleasure.
Take care of that.
Item number 24.
yes. The estimated cost tender under the price of 75,000. 3 crore 65 lakhs, 75,000. Yes. That matter the petitioner to other thing, otherwise. Matter to kindly and pay 165. 165, yes. The lecture for the computer generated matter. The technical. There are 5 bidders matter. I am PT Enterprise. The portal. So we qualified.
my lord, kindly have the next page.
Yes.
I was declared after the financial year, I was declared the L1. I will kindly note the bid price I quoted was 965. That is 44,78,480 rupees, less than the estimated cost. I'm pointing this out, matter. Once they ultimately gave the reason after the expense of tender, they say my bid was abnormally high.
It was below. It is how much?
It is by road. Yes, by
4478 480.
yes. Then, my lord, all of a sudden that page 167, without any reasons being assigned, they saw that the status of the tender is cancelled.
Yes.
My lord. Then, my lord, I submitted my representations and all. Then, my lord, kindly have paid 169. There was another NIT. This is for, my lord, ad hoc, for the same work but on ad hoc basis for 3 months only. It pays 169. The same work.
Yes.
My lord, I participated. In fact, I wrote this. I'm carrying out the work as per the ad hoc is concerned. Then, my lord, while this was going on, they issued the impute NIT again.
Without cancelling the other one.
The other one was cancelled. Cancelled without assigning any reason. Okay. I'm coming to that. Oh, they reissue the NIT again.
169.
Oh, lecture. I'm only showing the relevant document. The same work, same estimate post tender. This is what I'm imputing. That's the interim order in my opinion. What I'm imputing. Now, ultimately, my lord, kindly note, 25/3/2025, after we filed the writ petition, the earlier NIT was cancelled without assigning any reasons whatsoever. And subsequently, they re-advertised it. That is dated 25/3/2025. Now, ultimately, they furnished me the reasons at page 237. This is the 5th of March, April, man. They say 237. Yes. But with reference to your letter dated suspension, you inform that the rates cited by your firm, the financial bills were very high. They were in the contract at the rate the most financial loan to the government acted. I wonder how, my lord. My bid is 44 lakhs less than the estimated cost put to tender.
So what you are quoting the same price in all the
No.
bids.
No, I quote there was only one NIT that was cancelled without assigning any reason. This is the reason. They say that
So
your bid was
first there was an NIT.
yes,
Where you were the L1.
yes. There was
Not only L1, your price was well below the I'm sorry, the tender NIT price.
Yeah.
That was cancelled. Then a fresh NIT was issued.
This is the fresh NIT. The other one was for the ad hoc.
224. Now what happened in 224?
These were impugned, my lord, saying that, my lord, there was absolutely no reason why the earlier NIT could have been cancelled.
You are challenging
Yes.
this NIT.
Yes, ma'am. I am showing this 237 only for the purpose. This is the reason ultimately they have assigned.
On the basis of which your first tender was cancelled.
Yeah, they say my bid was very high. Now, how can that be, my lord? My bid was 44 lakhs less than the estimated cost put to tender.
So what is the status of this NIT now?
This is under statement.
Run the state.
It is my case. Yes, responded. One judgment. Come together, my lord. They have the power to, my lord, but it cannot keep that in our arbitration. And the reason assigned is it is abnormally high, my lord. When the bid price is 144 lakhs less than the estimated post-put data, how can it be abnormally high? Yes. There are 7 onwards, my lord. And 3, 1 is 6, 7, 12. Paragraph 7. In contractual dispute, as in all other state actions, the state and its instrumentalities have to conform to Article 14 of the Constitution, of which non-arbitrary is a significant facet. There is no unfettered discretion in public law. The public authority possesses powers only to use them for public good. This imposes a duty to act fairly and to adopt a procedure which is fair play in action. Due observance of this obligation as part of good administration raises a reasonable or legitimate expectation. Every citizen to be treated fairly in its interaction with the state and its instrumentalities, this element forming a necessary component of this process in all state action. To satisfy this requirement of non-arbitrariness in a state action, it is therefore necessary to consider and give due weight to the reasonable or legitimate expectations of the persons likely to be affected by the decision, or else that unfairness in the exercise of power may amount to an abuse or excess of power, apart from affecting the bona fides of decision in a given case. Decisions so made would be exposed to challenge on the ground of arbitrariness. Rule of law does not completely eliminate discretion, the exercise of power, as it is unrealistic, but provides for control of its exercise by judicial review. The mere reasonable or legitimate expectation of a citizen in such a situation may not itself be a distinct enforceable right, but failure to consider and give due weight to it may render the decision arbitrary. And this is how the requirement of due consideration of a legitimate expectation forms part of the principles of non-arbitrariness, a necessary concomitant of the rule of law. Every legitimate expectation is a relevant factor requiring due consideration in a fair decision-making process, whether the expectation of the claimant is reasonable or legitimate in the context of a question of fact in this case. Whenever the question arises, it is the larger public interest wherein other more important considerations may outweigh what would otherwise have been legitimate expectation of the claimant. A bona fide decision of the public authority reached in this manner will satisfy the requirement of non-arbitrariness and which then is good. The doctrine of legitimate expectation gets assimilated in the rule of law and operates in our legal system in the manner and to this extent. In such and such, the Lord indicated the extent of which legitimate expectation is. I will not go into this matter. Paragraph 10. From the above, it is clear that even though the highest tenderer can claim no right to have its tender accepted, there being a power while inviting tenders to reject all the tenders. Yet, the power to reject all the tenders cannot be exercised arbitrarily and must depend for its validity on the existence of cogent reasons for such actions. The object of inviting tenders for disposal of a commodity is to procure the highest price while giving equal opportunity to all the intending bidders to compete. Procuring the highest price will commit undoubtedly in public interest, and since the amounts of collected goes to the public fund. But ultimately, it could not have been done in arbitrary. The reasons as your lordship has seen, it's abnormally high. But the bill is 44 lakhs less than the estimated cost. That is my humble submission. Yes. So, yes, that's
Let's pay the list of this. Initially on 8/1/2025, NIT was floated for RTC X RH Harmony FSD Bandadeva to FSD Coloridian. The estimated value of the contract was mentioned at 3 crores 65 lakhs 75,000. Hello, this Coloridian from Bandadeva to Coloridian, because for the first time the FCI has floated the tender. Now the petitioner was L1. Madam, his quoted rate was 3 crores 20 lakh 96,500 ton. That is rupees 4520 per metric ton. And then after evaluation of the price weight, it was found L1. Thereafter, evaluation of the price weight, it was found that the rate is higher as compared with the other region matter. I will come to that matter. Therefore, the authority has decided to cancel the NIT and place the ad hoc tender for the time being. So on the 17/3/2025, the NIT dated 8/1/2025 was cancelled.
as pointed out by my learned friend, since it is the JAM portal, so in the JAM portal, we have stated that it has been cancelled, my lord. Thereafter, on 83/2025, after being cancelled, my lord, petitioner wrote a representation for reconsidering the decision to reject the tender. On 21/3/2025, prior ad hoc NIT was issued for the same route, my lord. And meanwhile, petitioner has participated in that route, and they have also challenged the earlier cancellation, my lord, that is 24/3/2025. Petitioner filed WPC number 123 of 2025. The matter came up for motion hearing, my lord, on 25/3/2025. The Honorable High Court issued notice of motion in WPC number 123 of 2025 and rejected the prayer for granting any interim order. So after that ad hoc evaluation of that order contract, my lord, the petitioner was found to be the alone, then ad hoc contract was given to him. 25/3/2025. And we have, at the same time, we have also issued the regular tender for 2 years after cancelling the first one. 25/3/2025 was the another NIT was issued for the regular tender.
How many NITs did you issue for the same one?
First of all, we have issued the first regular tender for 2 years. That was cancelled. Then we have issued.
Why was it cancelled?
It was cancelled because the rate was, we found it to be the high, man.
But his rate was lower. As
I am coming to it, my lord. Let me complete, my lord. So, my lord, FCI has replied to his representation that
we are not concerned with that. Why don't you come directly to the point which is an issue?
Yes, my lord, I am coming, man. So, in the ad hoc tender, my lord, his quoted rate was 3990 per MT, my lord. Earlier, he quoted the rate of 4520. It's fortified the fact that the rate was high.
Anything, Mr. Singh. There was an NIT floated where he quoted a tender.
Yes.
He quoted his rate.
Yes.
Then it was cancelled.
Yes.
And a subsequent
ad
hoc or whatever was issued. Now he is challenging the first cancellation on the for reasons which you say he had quoted a high rate.
It was a high rate, as compared with the other region, my lord. That fact has been fortified by the my lord. The petitioner himself has quoted 3990 in the ad hoc, my lord.
No. How can there be a rate quoted by a person as compared to the other regions? Then you have already indicated in the cost factor involved in the NIT.
That is the estimated value of the cost. I will take your logic in my paragraph 5, paragraph 6 of my affidavit in opposition, that is page 6. My lord, earlier when the ad hoc tender he became L1, my lord, quoting 3990, he has accepted that tender, my lord, and thereafter they have withdrawn that earlier rate petition, my lord, without taking leave of this honorable court, wherein the similar prayer was there. He has conveniently withdrawn, now again conveniently has filed this present writ petition challenging the issue.
His choice to come and go unless you say that no liberty was granted.
Liberty has not been granted.
It was not required because the earlier the cancellation of the tender was put to challenge. They subsequently issued the fresh and they put to challenge it.
My lord, in earlier tender, cancellation was also challenged, my lord. Two prayers were similar, my lord. So you have withdrawn that writ petition, my lord. Writ petition number 123 of 2025, my lord.
That's a fresh cause of action now.
No. Fresh cause of action for this present writ petition, present NIT, not for the earlier NIT, for the cancellation, my lord. That is also I have taken my point in my affidavit in office. My lord, at page 256. I will read out only one paragraph, my lord. Para 6. That I say that the FCI respondent had for the first time has invited NIT dated 8/1/2025 for appointment of road transport contract at Harmony FLC, but they were to FLC Colorant via V3 for the entire distance. State route to Colorant is the new route for the FCI. As said, NIT dated 8/1/2025 was plotted for the first time. However, the FCI received the rate of 4520 per MT as L1, which was significantly on higher side. Therefore, the FCI respondent took a decision to cancel the state NIT dated 8/1/2025 and call for an ad hoc NIT dated 21/3/2025 as floating of regular tender would take another 3 months for finalization. I further say that the reason behind for the cancelling the same tender has taken place on the various grounds. FCI has full authority to explore the possibility of getting a competitive rate. The decision has been taken as per the clause 4.4 of the contract manual, which is quoted very. I have annexed also my lord, contract minor relevant paragraph. 4.4 reasonability of the tender rate. Reasonability of the tender rate should be examined in a transparent way.
No, I have not understood any one thing. You have floated a tender showing a tender price, contract price.
Quoted price,
That
estimated quoted price.
Estimated.
Quoted price.
somebody, which means that 5 or 10% beyond that you are supposed to reject it. I don't know what your conditions are. Normally, variance at the rate of 5 or 10% of the quoted price is acceptable. Here is somebody who has quoted much below.
But it is expected to the ratio outcome of they have been quoted by the petitioner matter. I mean, it has been quoted by the petitioner himself. He has quoted the next tender. He has quoted 3990 matter instead of 4520. Now again, that ad hoc tender has been expired matter. Again, we have issued another ad hoc tender for 3 months. Well, there is a rate has come to 880 matter. My lord, may kindly peruse the latter.
Here we are not on that. We are asking that you have cancelled first tender.
Yes, ma'am.
On the ground of the communication which you have given that he has quoted high.
No, my lord, let me read it again, my lord. Page 237 of the writ petition, my lord.
37
of the writ petition, last page. With reference to your letter dated 18/3/2025, it is to inform that the rates cited by your firm in the financial bid were high, and awarding the contract at the rate would have caused huge financial loss to the government exchequer. Further, ad hoc tender was floated for the same center by the divisional manager D.O. Pandit Deva. The L1 rate of the ad hoc tender discovered is far lower than the ones quoted by your firm in the aforesaid regular tender. In view of the above, the representation given by your firm holds no mean and is
What kind of a ground for rejection is this? It is as good as saying tomorrow you float another tender for the same area and you will go back to some other rate quoted in some tender floated. Say that the rates quoted by those people are far less, therefore your rates are higher. It is you who have given the where is that contract? NIT.
In the affidavit, they have annexed nothing. I don't think an exercise was carried out on cancel.
If required, I will produce.
No, you said the file.
DDP2, you have given the prices. Estimated value of contract you indicated.
This is estimated, my lord. It is likely to that the value of the contract will be 3 crore 65 lakhs based on the present rate of based on the estimated.
So somebody who quotes lower, you say that his rates are higher than the rates quoted.
Abnormally high, man.
We have to work out the reasonability of the rate, my lord. That has been worked out, my lord.
That reasonability has to be worked out, making this quoted the value of the contract as the base rate.
Yes, my lord.
Then,
so
what kind of grounds are you using?
Hello, if need be, I can produce the record, my lord. How this?
We are not interested in your records. You already filed your counter evidence.
Yes, I'm relying on my counter evidence. So, my lord, on further, I was reading paragraph 16, 6, my lord.
Yes.
7.
Yes.
Suitability of the tender rate should be examined in a transparent way after observing relevant PFR guidelines and FCI instructions from time to time with proper documentation, reference before acceptance or rejection of any tender rate. While examining the reasonability of the offer rate should be done in absolute terms of the rate with nearby other existing FCI, CWC, FWC, other PSU discover tender rate and prevailing market rate for similar services. Prevailing market rate be obtained just prior to the opening of the technical. I say that as per the same clause of the reasonability of quoted rate was examined by the authority by comparing the rate with nearby other existing rate and prevailing market rate for similar services. Furthermore, the majority of the contracts were awarded at rates below the prescribed market rate for the respective area. Petitioner's allegation that the rate quoted by him NIP dated 8/1/2025 is lower than the PMR or the
PMR is prescribed market rate, or the estimated contract value is unfounded as the rates approved by this office in any contract are already below the PMR received. No, this is supposed to have been worked out at the time when you reflect your contract price value. My lord, at the time of evaluation, it has been worked out, my lord. Thereafter, the authority has come to this conclusion. Again, with the press and ad hoc analysis, there is the same manner. Who are these contractors whose rates are applicable? Whose rates are you relying as a base rate? To say that compared with the other routes, my lord, there are different routes of the FCI, my lord. Like maybe, but how can you use that as a base rate? Compare it, my lord, with the other routes and the PMR, my lord, prescribed market and prescribed market rate. Then why do you have to apply for a tender? All those. Can you bear with me? That is fortified by the fact that since there was a stake, another ad hoc tender, we have got the rate of 2880, my lord. It is almost 2000 rate, lesser rate, my lord. Than tomorrow for a particular tender, somebody else may quote lesser than him. We cancel that one tender, then next NIT, we are expecting that the rate will come at very competitive rate. But then what basis? No, but why? You are entitled to float and withdraw or cancel your tenders, but for good reason. Yes, my lord, there is no arbitrary. That is what we have to satisfy. When you say that the rate quoted by the petitioner know the contract value, how can you say that these rates are higher and you say that there is no arbitrary? Like I've listened to my own. What the same route? What the same route, man? In which NIT? My lord, the subsequent ad hoc tender. Because there was a state of now this stock there is being. So where is the guarantee? Where is the guarantee that this tenderer for some reasons this tenderer, or you may have sent this tenderer to understand that anything below a particular rate would be acceptable rate for you. On the last, you have to give us a German to float a tender, give conditions. You say the value of the contract is that. Why is the value of the contract fixed? This to show give an idea to the contractor exactly what is the value may go. It may estimated value of the tank. It may go up or it may go down. It's a different issue. It is always, my lord, it is always found that the rates are below. Let me tell you the kind of proposition you are trying to project is. I'm finding it very confusing. Let us say tomorrow, for a particular area, you floating a tender, and somebody quotes higher than the quoted price. But you find that this is at par with the other similar areas, you consider the N1. And in a given case, even if a person quotes below the quoted price, why will we do? Why we have worked out here? Because this was for the first time we have quoted the tender of this. That is the reason. So we have to work out. You work out before you float a tender. How can you work out after you float a tender? We have given the estimated rate, my lord. It is fortified by the fact that, my lord, the petitioner himself has quoted 3990 in the ad hoc tender. I would like to rely on the, my lord, of the Air India paragraph 7 of the. No. These judgments, there is no quarrel on that. First, we have to hear us on the facts. On what basis have you calculated? You must say that, all right, we got the information that in a similar tender, he had quoted far below. Maybe that would be one good reason. I don't know. The problem is here, my lord, this is the 41st time NIT has been quoted. This is the new area, my lord, followed in respect one state FFP has come out, my lord. So that's why the reason. On one hand, you say there are other persons who have quoted below in similar tenders.
Yes, after the first NIT was cancelled, we have quoted the ad hoc tender, so has
You cancelled it on what ground?
cancelled it because it has gone to be higher.
Which information, according to your own statement now, you have come to be informed of later after cancellation?
Worked out, I don't. I mean, completely nonsense.
Prima facie, it doesn't smell good. You have floated a tender. You have allowed persons to participate. You give good reasons that in similar areas, from our information, rates quoted are higher, although you are the L1. This is not the statement that you have given.
But if I make a sit out the
What notes you?
tender,
You bring it on record if you want to. Bring it on record if you want.
I will file by the
Bring it on record.
additional.
Why should we examine your note sheet? You explain, you have already filed an affidavit to explain as to what is the basis on which you have cancelled the tender. You want to bring it on record, you bring it on record. Whatever you want to bring it, but the explanation which you are giving for cancellation of a tender, that after floating of tender, after inviting the rates, you make inquiries to find out from others, and at the same time you say that this is a new area, this is the first tender you have floated. So where did you get this information?
By comparing the
How will you compare? How?
by getting the idea, madam. They are the
What idea? What idea?
I will by way of additional affidavit, I will.
Out of record, there is nothing. Currently, there is nothing.
Third council for parties matter will be listed after. Interim order will continue until further orders.
2 weeks, madam.
No. You bring it on record. You don't seem to be on last week you made a mention that it's very urgent matter and there's an interim order. Today you are praying for filing an additional affidavit to bring on record.
You also wanted to see the through the and
We are not
otherwise
interested. We are not interested to see your records, Mr. Counsel. It is you who have offered to justify your arguments or put it on the court. We are not interested to see your records. We want to know what is the decision that you have taken. We are only concerned to find out how you have arrived at the decision. When on one hand you say that you cancelled it after finding it higher by comparing with other rates. On the contrary, you say, no, this is a new area. You were not aware of what rates were feasible. Therefore, to give an idea, you have quoted the contract price. These are contradictory statements.
no, not exactly, my lord.
Yes, list after 4 weeks.
2 weeks, fine.
You mentioned it, you can find it earlier, you mentioned it.
Unlisted item number 25.
Yes.
Yeah, please, madam. I am challenging the transfer order dated, madam, 28/8/2025, madam, which was issued on 29/8/2025.
Page number?
Page 32, madam. In violation of the madam professed norm of transfer from the state of Arunachal Pradesh, madam. Page 32, madam. May I read, madam? In interest of the public service, the following officers of AP Civil Secretariat matter, it is within the Civil Secretariat matter, are hereby transferred and posted in Indian effect. It's serial number 2, matter. Rigo Vam, EWG establishment, duty housing matter. Right? Serial number 2, matter. And in the bottom of the state transfer order matter, stated that matter. The above mentioned officers are hereby directed to join their new place of posting immediately and further no representation for the cancellation of the transfer posting order will be entertained. I have been debarred from submitting any representation matter against the transfer order matter. And in the present place of transfer matter, posting matter, I was transferred on by order dated 3/2/2025, 475 at page 26 minor.
The last transfer order matter is matter of 3 to 2025 matter.
Yes.
And within a period of matter 7 months matter, I have been transferred again matter
26, page 26.
26 matter.
Your name and serial number 1.
One matter. Thereafter, matter by the impure order issued on 29th matter, the order dated 28/8/2025, issued on 29/8/2025. There is a process norm which is being followed in the state of Arunachal Pradesh governing the transfer and posting matter. There are two categories of employees in the state of Arunachal Pradesh. One category matter is matter the employees of the civil secretariat matter. The transfer can be made only within the minor civil secretariat matter. Rest category of employees is minor, that they can be transferred to any part of the state of Arunachal Pradesh matter, irrespective of other departments matter. That minor policy also will find at least minor 27 is the type copy, minor is the original minor, and the type copy is at page 30 minor. This is the minor guidelines minor being followed in the state. Okay. 1988 minor. Clause 1 E minor. All the postings, including those in the secretariat, in the office of the head of the department and in the district, should be normally for a period of 3 years minor. The tenure is minor 3 years minor. And when come to minor E minor, no transfer should be take place in the last 3 months of the financial year. And minor and 3 minor, serial number 3 minor, the procedures to be followed in indicated. The officers of postal transfer shall be issued by the April, immediately after the financial year end, so that the implementation of the plan scheme and budget expenditure are not affected by such orders. Thereafter, madam, kindly see at page 31, madam, in conclusion. 5, madam, is proposal reported by the C madam. The head of it concern shall release the officer job transfer by the first half of the May madam. Thereafter, madam, 5 madam, each proposal of transfer must clearly insist on the file that will satisfy all the conditions 1, 2, and 3 madam. Basically, where it's a midterm transfer and the madam transfer is violation of the madam mandatory period madam. And by this, though my lord, this notification has been my lord superseded by my lord, the another my lord order my lord, it pays my lord.
So instead of 3 years, it became 2 years.
It became 2 years my lord, pays 34 my lord. My lord, thereafter my lord, the departments and the secretaries are not following scrupulously the guidelines my lord. So a circular has been issued by the my lord, chief secretary my lord. It pays my lord 35. And type copy is at page 36, madam. May I read, madam, for a moment, madam?
Yes.
In inviting a reference to the government order number June 1998, madam, is the same and amendment number order 19/12/2008 regarding policy guidelines of transfer and posting of all categories of officers and the staff under the guidelines. Hence, the aforesaid transfer posting policy guidelines are required for strict compliance of the department. Further, in the area of clarified items, terms of the guidelines under the reference, the normal technical posting for all the categories of officer and study yes, minor.
Yes.
By the impure transfer order minor, even minor, my representation, filing of representation has been deferred minor. Minor.
Yes. Why the respondent? Why are you transferring middle of the term?
Or minor. Minor may have read it minor. Yes, because my no minor. I have been deferred from submitting representation minor. Minor. Minor.
Deferring the submitting representative.
So the violation of our honorable court judgment also minor. In Cinematic P. Secos versus State of Nagaland matter reported in 1995 to GLK 101.
My lord, may I propose and pray that, my lord? My lord, let me file my lord representation before the authority, my lord. And
Provided you file it
yes,
by
my lord.
Friday,
My lord,
not later than that.
my lord. And till
And within how much time?
15 days, my lord, let them dispose, my lord.
Weeks?
2 weeks, my lord.
Give 2 weeks. Let it be disposed of. And then pass orders, speaking orders. In that time, order will not be given effective. So far as the petition is concerned. But Mr. Rarasoi here, the council as well as Mr. S. Napi, the senior government advocate, appearing for this law states. But you have made a private respondent. What about him? He has joined or not?
No, my lord.
Huh?
Yellow CP has not joined.
This petition is filed by the petitioner. Challenge the order dated 28th of August 2025, whereby stated established branch. The civil secretary. Civil secretary. Tanagar was transferred and posted at urban development and housing branch. So, person named at serial number who was posted in urban development and housing branch. So, council submits that by order dated 3rd of February 2025, the petitioner was posted at the PWP establishment branch. And the field order is issued after about within 5 months of its posting by the earlier order dated 3rd of February 2025. Council petitioner has record guidelines issued by the state on 2nd of 1998 submit that no transfer should take place in the last 3 months of the election. And normally the transfer should stop. The guidelines came something to be amended by an order dated 19 December 2008, whereby tenure of posting was modified to that of 2 years instead of 3 years, as earlier specified in guidelines. So, council submits that specific or complete inquiry transferred out. Now, that apart, he has been debarred from filing representation to authorities, which specifically mentioned some circumstances. Commissioner has made specific, has made and permitting to file a representation to concerned authority and authorities directly school governments to the six states. So there's nothing that is thinking of that. The other end submits that he does not have instructions to the reasons leading to the transfer of the liquid petitioner midterm. So therefore submits that he probably instruction. So, having heard down to the one. Sport transfer. Is private representation or taking these drugs against the transfer. By thereby is transfer properties. Increase of posting. However, the order 28 of August 2025 said specifically mentioned that the officers directly posting no further representation would cancel transfer of posting order. So it's further in the specific amendment in the petition that the private respondent slash the reliever of the writ petitioner has not joined in his case of post. And the petitioner has also not handed over charge. So, under such circumstances, it's considered is of the considered view that ventilating of remarks in concerned authority is incompetent or the rules of natural justice. So, any employee having any remarks, he is permitted under law to approach the competent authority ventilating his or her remarks. Restraining any employees from filing representation is contrary to good governance and proper administration. So, under such circumstances, this court then the should get the direction the Secretary SA, Government of Arunachal Pradesh. Yeah, direction dispose of the writ petition, permitting the writ petitioner to file necessary representation before the competent authority, namely Secretary SA, Government of Arunachal Pradesh, within 3 working days. And if such a representation is filed before the said office, the same shall be received, be considered, and upon taking into account the answers calculated by the petitioner and the other relevant materials, the same shall be disposed of, speaking order. So, copy of the said order shall also serve on the petition. So, it is ordered accordingly. This representation, if filed in 3 working days directly, shall be disposed of in 15 days therefrom, and a copy thereof. Copy of the speaking order be served on the petition. So, then such order is passed by the respondent authority. The due order dated shall not be given effect. The petition accordingly stands as closed.
Item number 26.
In terms of the instruction received by the council, submitted that in terms of the instruction received by the petition, council submits that Not this personal.
Lordship, we are trying for the withdrawal. With the liberty.
Don't withdraw. With liberty.
Lordship,
You want liberty?
Lordship.
It's not withdraw. Interim order, when it's set, maybe pending higher or something.
Yummy. अभी का unlisted वाला